I'm also going to jump in on the question of legal representation. If it is suggested that the public protector has a right to representation, as the president has, perhaps on the grounds of irrational difference, that there should not be an irrational difference between the president and the speaker in respect of legal representation, that the president could lose all benefits and not serve again in public office. Is there a rational basis for the differentiation?
As I've indicated, it's the difference in the consequences. The consequences in the case of the president are punitive. What is this about? I suppose one takes a step back. It's about what this court called in one of its earlier judgments, a Mazibuku case, democratic hygiene. The removal of someone from an office is not punitive. It is to ensure that our important institutions are staffed by people who are not incompetent or have misconducted themselves or for whatever reason incapable of doing their function, performing their functions. It's not punitive. In the case of the president, it is punitive. The reason is that the National Assembly has the power to remove the president on the basis of poor performance, if I can call it that, through a motion of no confidence under section 102(2). That's not punitive. And it's the punitive element which justifies the difference from a rationality perspective.
Is section 34 applicable in this matter?
No.
Why do you say no?
Because section 34 concerns hearings in courts of law. This is a parliamentary process aimed, as I've said, at determining whether the incumbent of an office should carry on. Section 34 is no application. Otherwise, the point would be that it couldn't be done by Parliament at all. It would have to go to a court. But the Constitution determines that the factual issue must be determined by a committee of the National Assembly, and the Assembly as a whole must vote on whether, if someone is indeed found to be incompetent, etc., whether the person must be removed.
And is section 57, which empowers Parliament to make rules concerning its business, is that section relevant?
Highly relevant. So it raises a separation of powers issue here. Not only is the Constitution given the job of conducting impeachment inquiries to the National Assembly and its committee, but the point that I would have made had I moved on to discussing the similarities and differences between section 89 and 194 is that the similarities are such that the majority's holdings in the EFF impeachment case are applicable here. More specifically, that Parliament had to adopt rules which define the grounds of misconduct, incapacity and incompetence, and importantly, for present purposes, regulate the entire process in the Assembly. And Parliament has done so, and the issue, therefore, in other words, there's no legality problem. So the only possible basis for a challenge is then rationality when it comes to the rules. And I've made my submissions as to our main reason why, our main contention why it's rational to ensure personal accountability, and also the rationality of the differentiation on which I've been questioned.
Thank you, Mr. Breitenbach.
Sorry,
I'm sorry to
Mr. Breitenbach, if I may, Justice Madanga, follow up. I also have concerns around the legal representation issue. And one must be careful, I would suggest, that one does not set precedent based on a particular facts in the case. Now, conceivably here, there are only primarily, not only primarily, legal issues at play as to whether there is incompetence or misconduct based on several decisions of the courts. But there may well be an instance where a Chapter 9 office bearer has to face disputes of fact issues where certain misconduct, for example, is alleged, and that Chapter 9 office bearer denies that misconduct or the import of it. Now, it bothers me that the legal representation is limited. You know as well as I do that Wigmore called cross-examination the greatest engine ever invented to test the truth. I'm not so sure if he was right with that, but we do understand that truth and veracity could only properly be tested where there's a contestation of facts through cross-examination, and it does concern me greatly that the legal representative would not be able to cross-examine and, more importantly, make submissions. Lastly, just to ponder the thought that much is made of the fact that the public protector is legally qualified and has legal knowledge, and it's pointed out by my colleague, Justice Tiki, that wouldn't always be the case. But in any event, it is often said that even if you do have the choice where you choose, even as a lawyer, to represent yourself, you have a fool as a lawyer. And it concerns me greatly that in such an important institution, arguably the most important institution under Chapter 9 for our democratic accountability, legal representation is limited. I fail to see on the argument of the differentiation where the rationality is, unless you can persuade me otherwise. I have grave concerns about that, Mr. Breitenbach.
Justice Majid, firstly, in response to the point about one mustn't focus on the facts of this case, I respectfully agree with that, and I respectfully, consequently, accept that the legal qualifications of the public protector do not present an answer to the points arising in this matter. This public protector is one among many people, Chapter 9 office bearers in jeopardy. So I accept that. As to the question of rationality, Justice Majid, in one of the cases on which the court below relied, Hamata, a case dealing with legal representation in a disciplinary inquiry at a higher education institution. It is interesting to note, and I commend the court to the judgment, not because this is administrative action. We say Hamata is distinguishable. We also say Hamata is distinguishable on the other basis that there was an entire denial of legal representation by an external lawyer in that case. Here it's permitted. But what is, I respectfully suggest, of assistance in deciding this matter from Hamata are the warnings at several places through the in the judgment, which really touch on this, and I say this with the greatest respect. We as lawyers tend to want to over-legalize proceedings. Yes, these are legal proceedings, but the involvement of lawyers does create problems. In this case, the problem identified, and in its most extreme form, is the problems, or the problem from Parliament's perspective with the impeachment process in the US, where the person concerned didn't speak at all. Everything was done, didn't even enter the chamber in that case. Our choice is for personal accountability. And the nub of the issue which you have to decide is this. I can see from the, and sense from the questions being directed to me, that members of the court are uncomfortable. They would not have included the proviso to 129 AD3. They would have left it the provision without the proviso, as is the case in the equivalent rule 129 M, if I recall correctly, M3, in relation to the president. But the question is, is this one of those cases where what one has is an irrational exclusion? It's not rationally related to this purpose of ensuring personal accountability, or an irrational differentiation? Or is it one of the cases on the other side of the line where the members of the court, if they'd crafted the rules, would have done things differently, but it's not for the court to interfere with a choice which Parliament has made? It's one of the big separation of powers issues in this case, and it is actually, Justice Majid's question has put his finger on the issue for decision as I see it respectfully.
Mr. Breitenbach, just lastly on this aspect, what exacerbates my concerns is the fact, I know it's a different issue, but I think it's related. What exacerbates my concerns is the fact that the public protector really only has two opportunities to be heard. And the first one is when the independent panel sort of finishes their report and finishes the public protector with all the information at its disposal and affords her an opportunity to respond to what their findings are, the recommendations will be. And secondly, and most importantly, is this, where the Section 194 committee now has to consider evidence and so forth to be able to make a recommendation to the full National Assembly. Now, that limited opportunity for participation exacerbates my concerns that the legal representative really just sits there and furnishes advice from time to time. You say we tend to over-legalize matters, but I can conceivably imagine a situation where there's endless applications and motions for adjournment to seek legal advice on issue A, and when we come back, there's issue B, and so we eventually run out of letters of the alphabet as the adjournments continue. Why should that be so? I'm really concerned about that.
So that is a consequence of Parliament's choice. Parliament has said, firstly, that the committee must ensure that the inquiry is conducted in a reasonable and procedurally fair manner and within a reasonable time frame. And secondly, that the committee must afford the holder of public office the right to be heard in his or her defense and to be assisted by a legal practitioner or other expert. But then comes the proviso, that person may not participate. That's the only limitation. It will be a difficult meeting to chair. I have no doubt. If in a case such as the one which you have mentioned, whether it will be a difficult meeting to chair in this case, I'm not so sure, because one is dealing here with reports, with affidavits and things which have already been said about them by courts. But that's Parliament's choice. And my basic submission is that while certain members of the court may have crafted this rule differently, is it irrational to have crafted it in this way? That is the difficult question raised by this aspect of the matter.
Thank you. Thank you, Justice Matlanga.
Mr. Breitenbach, for the appointment, to be appointed as the Auditor General, there are certain statutory requirements, legal qualifications that you must meet. You must somehow be an expert in that field. And the same would apply to the public protector. There's a certain threshold that you must meet for you to be appointed. And it appears for one to be appointed as the president, such requirements are not there, which brings me to the fact that it could be merely a political appointment without necessarily being an expert or having the experience or the knowledge of being the president. Now, to test the competency of a person, will that differentiation not be relevant in this kind of inquiries, where you would want your appointee or incumbent in the office to show those skills of competency when the person has to account? I don't know whether I've made my point very, very clear to you.
Undoubtedly, if I understand you correctly, your point is that Section 193 of the Constitution, in addition to specifying, specifies in 193 sub 3 the requirements for appointment as the Auditor General.
Yes.
The person must be a South African citizen, a fit and proper person to hold the office, and then specialized knowledge or experience in state finances and public administration must be given due regard. So they are specialists in auditing state finances and public administration. That's now the Auditor General. So such a person, and I've accepted that, needn't have legal qualifications. And I must accept will be at somewhat of a disadvantage in dealing with, for instance, as was put to me, contested questions of fact. You did this. Let's say the ground of impeachment goes to fitness and propriety. In other words, it is a charge of misconduct, as opposed to a charge of incompetence, which the Auditor General would be relatively easily able to deal with from their experience and because of who they are. It's those cases, I surmise, which are at the root of the discomfort of the members of the court put to me. And my answer to that is that these are nevertheless very senior public officials, people who are inherently capable. In the case of the Auditor General, it would be someone who is able to deal with a lot of information, analyze it, and express an audit opinion on it. Nevertheless, not a lawyer. Is it rational to limit their legal representation to representation is effectively outside the committee? The person can be there but not speak. That is the question. My contention is, because of the primacy attached to personal accountability, it is rational in the sense that it's rationally related to that outcome. Yes, it has a downside. I accept that. But the question is whether that downside is such as to render it irrational.
Thank you.
Mr. Breitenbach, can I ask you this? I understand the rational connection between the prohibition to be the promotion of personal accountability. Is that correct?
Yes.
You will accept that allowing full legal representation in any context doesn't mean that the lawyer can give evidence on behalf of the client.
I agree with that.
The procedure to be followed by if we were in the realm of disputed facts, it would then be for the public protector to give evidence or to face. I think under the committee procedure, she might be compelled to give evidence. They could require her to answer questions, but assuming for the moment that she didn't, well, then there would be an adverse inference. But the normal position would be that if there are disputed facts, she will need to give evidence.
Or bring witnesses, yes.
Or bring witnesses. And if she gives evidence herself, this applies to any head of one of these institutions, she will need to engage with the members of the committee if they ask her questions.
Undoubtedly, yes.
So giving full legal representation doesn't shield her from accountability in the sense that she will personally have to answer questions. Do you accept that?
I agree with that. And that may well be a distinction between what happened in America, which the speaker has spoken against, and what will happen in an inquiry here.
Yes, I was going to say I don't understand how the Senate procedures work, so I'm not sure it was a good comparison. Now, if there's going to be personal accountability through having to give evidence personally and answer questions personally, despite full legal representation, can I just probe what then additionally the prohibition on legal representation achieves by way of personal accountability? The first thing is it would deprive, let us just talk about the public protector, but it would apply to any head. It would deprive the public protector of a lawyer potentially objecting to improper questions.
Or objecting generally, whether the objection is well-founded or not.
Yes, and if it was not well-founded, one must assume it would be disallowed, because I assume the committee can also have its own legal advisor. But it deprives her of the opportunity of a lawyer to shield her from improper questioning.
Yes.
That's the end view of your legal representation.
It also deprives her of the opportunity at the end of the case, when all the evidence is in, for somebody who is not, as it were, personally anxious or tense about a matter bearing very heavily on their reputation and future, to collect the best points that can be made and to put them up in argument. Because this hearing is about whether she did anything wrong. It's not about whether she is a good advocate or a good arguer. So in what sense is accountability, personal accountability, deprived or minimized or inhibited materially when at the end of the case, after she personally has answered all the proper questions that can be put to her by the committee, a lawyer on her behalf can, as it were, put the best argument forward that can be made for her?
The answer is that the lawyer may also artfully avoid dealing with issues which, had she had to deal with them herself, or had she dealt with the matter herself, she would have dealt with. That's the first point. The second is that it's indirect. What Parliament has opted for is for her direct involvement in the committee. She herself will perform these tasks, all of them. Yes, that may be uncomfortable, and she may not do some of them or perform some of them as well as as a lawyer, a skilled lawyer on her behalf would do that. But Parliament wishes to hear from her when she engages with witnesses and when she sums up her defense at the end of the case.
But sorry, carry on.
Because it's about her personal accountability to Parliament. And so that there is obviously a different way of dealing with this. My basic submission is it irrational to require that she deals with the inquiry herself in the sense of speaking herself, taking advice where necessary?
But I come back to the point, it's not a test of how well she can argue the case at the end. In her evidence, she deals with the misconduct which is actually being put to her. But if at the end some argument is not dealt with by her lawyer, or even if it is, surely the committee can chip in at any stage and say, well, Ms. Makwabani, if it's her, what do you say about this? Or Ms. Makwabani, we'd like you to deal with some aspect that your lawyer hasn't dealt with. None of that is precluded just because you allow legal representation.
I understand that, but the committee will nevertheless, in the instances in which the lawyer is engaged, whether it's in questioning witnesses, in leading witnesses, or in summing up the case, be hearing from someone other than her. And Parliament's choice is, in this case, deliberate because of the addition to the proviso to to an equivalent rule where the lawyer is not restricted in this way, is that it wishes to hear from the Chapter 9 office bearer at every stage and in every facet of its business.
Thank you.
Justice Madlanga, I would like to ask your permission to step off this. I've made more or less the submissions that I wish to make on the ground of appeal, which are allocated to me. There are one or two other points that I would wish to deal with you and the court's permission. I don't want to cut short any.
I understand perfectly. I mean, the minute you said we should start asking questions, we pounced on you and you've not put in a word of yours. Mr. Breinbach, how much more time do you think you want?
I'm going to adjust what I had in mind and just refer the court to parts of our submissions on certain things rather than deal with them. And I can't say, but hopefully no more than 20 minutes. I'll try and be as brief as possible.
I'll be liberal and give you the 20 minutes.
Thank you.
Thank you, Mr. President.
I've already dealt in passing with the first topic that I wish to argue, which is the implications for the decision of the present matter of the similarities and differences between Section 89 and 194 of the Constitution. I would just emphasize the following. There are three similarities between the two provisions, which we suggest render applicable the reasoning of the majority in the EFF impeachment case. The first is both confer the power of removal on the Assembly. Secondly, they require the Assembly to exercise that power by means of a resolution. And thirdly, both contain grounds of removal. But the other thing they have in common, although Section 194 is more detailed, is that they are still skeletal provisions. And indeed, if one looks, for instance, at the grounds for removal in 189, 1A and B, they are more detailed than the simple ground of misconduct in Section 194, 1A. Yet, this court held in the EFF impeachment case that the Assembly has an obligation to adopt rules which define those grounds. And we say the same obligation is imposed on the Assembly by Section 194. And similarly, and this goes the other way, yes, the procedure in 189.1 is much more abbreviated than the procedure in 194. There's simply a mention of the grounds and the fact that there must be a resolution of the Assembly. There are three stages, as the court knows, in the 194 process. There's the finding, by the committee that of incompetence, etc. There's the resolution by the Assembly, and then there's the actual act of removal by the President. The latter we submit is a formal act because it's a must. The decision is taken by the Assembly and must be given effect to. But nevertheless, we submit that this court will derive guidance from the part of EFF impeachment dealing with the process. And we refer the court in particular to paragraphs 181, 180, 181, 189, 190, and 192, where three important findings were made as regards the contents of those rules. The first is the rules must describe the manner in which the process must be initiated. That's in 181. Secondly, they must create a sifting mechanism to determine whether the President has a case to answer in 189. And thirdly, they must make provision for this preliminary inquiry during which a specially constituted a committee of the Assembly determines that a list of grounds exists. That's in paras 180, 190 to 192. An interesting feature of that case is although no provision was made for such a committee in 89 and provision is made expressly in 194, this court held that that was what was implicit in the provision because a finding of fact was required. Now, we consequently submit that we're busy here with rules made by the Assembly in the discharge of its duty to define the grounds and regulate the process as required by the EFF impeachment case. That brings me to leave to appeal directly to this court. We've dealt with this in our submissions at pages 13 to 15, paragraphs 30 to 35. Our basic submissions are that it is in the interest of justice for this court to hear a direct appeal. There are four reasons for that. The nature of the constitutional issues, they implicate the separation of powers. As the court will have seen from the debate, will know from the debate that we've just had about 129 AD3. The ground on which 129V was held to be unconstitutional was a separation of powers ground. So this undoubtedly implicates the separation of powers. And this court, as was held in EFF and Speaker 2016-3 SA 580, that's commonly known as EFF Nkandla, the Nkandla case, at paragraph 19, this court is best placed to take decisions on issues which have critical implications for the separation of powers. The second thing is that the issues raised by the appeal, as distinct from the cross appeal, and specifically their issues concerning the Speaker's bona fides and the claim for punitive costs, but the issues in the appeal are purely legal issues. The third, and we emphasize this, is that the proceedings currently pending in the Assembly in relation to the motion for the removal of the applicant in the court below, the incumbent public protector, we submit they are important and must be concluded one way or the other as soon as possible. And lastly, if the matter to proceed via the SCA, it's highly likely that a further application for leave to appeal to this court will ensue, and the result is it would cause a significant delay. I do not intend making any further submissions on the ground of appeal, which I would be arguing, the 129(a)(d)(3) ground. And I'd like then to turn to the issue of the cross appeal. The first matter there is leave to cross appeal. And Advocate Mkhwebane has made a conditional application. The condition is the granting by this court of the Speaker's and the DA's applications for leave. And what she seeks is a rehearing of 7 of her attacks on the new rules and on the Speaker's conduct, as well as, and she wishes to appeal against the High Court's refusal to make a punitive personal costs order against Ms. Modise. Now, we submit that unlike the application for leave to appeal, this application for leave to cross appeal is not in the interests of justice. Our first point is that she's failed to set out her grounds of appeal clearly and completely in her affidavit. Skeletal in many cases is, I respectfully suggest, an understatement. The second is the conditional nature of this application. The basic point there is that she appears to be willing to accept the High Court's rejection of the rest of her attacks as long as this court doesn't allow the appeal. But if the court allows an appeal, just the application for leave to appeal, the main application, well, then she wants to cross appeal. And that, we submit, is a factor against the granting of leave to appeal. It suggests that she's not really serious about those grounds. And lastly, and obviously we submit most importantly, we say, as will appear from my submissions and my learned friend Mr. Budlander's submissions on the remainder of the grounds, none of them bears reasonable prospects of success. That then takes me to the first of her grounds that I'm going to deal, which is under the heading procedural irrationality. We deal with in our heads at pages 36 to 38, paragraphs 88 to 92. And it has to do with the High Court's finding that there was nothing procedurally irrational in the rule's omission of a hearing for a Chapter 9 office bearer before the Speaker decides whether a motion for a removal from office is in order. The court will recall that's the initial first sifting mechanism under Rule 129S, read with Rule 129R. And we submit that when considering this issue, it's important to bear the following 2 things in mind. The first thing is that there's no such thing as a free-floating standard of fairness that applies to decisions or actions which are not administrative action, as we have submitted the functions performed by the Assembly and its officers are not here. It's common cause that we're not dealing with administrative action, and our learned friends have hung their hat certainly on the court below on procedural rationality. And as we understand that concept, what it entails is you must look at the process as a whole, determine whether the steps in the process are rationally related to the end sought to be achieved, and if not, whether the absence of a connection between a particular step, part of the means, is so unrelated to the end as to taint the whole process with irrationality. So what she essentially has to show is that the absence of a hearing before the motion is certified renders the process irrational, because the process is to determine, firstly, at the first instance, whether she is indeed guilty as charged. And it's the absence of a hearing at the time of the vetting of the motion to determine whether it complies with the manner and form requirements, primarily in Section 129R. And we submit that there's no basis for contending that the absence of a hearing at that stage renders the rules irrational in the procedural sense. The first is we're busy here with a preliminary screening function. The speaker's role is only to ensure that their motions comply with these form and content requirements. But secondly, and importantly, the rules do, as was pointed out to me earlier on, provide the Chapter 9 office bearer with a fair opportunity to address the charges against them at an early stage in the process. And of course, there's the second opportunity in the actual Section 194 committee. But let's just focus on the early stage. And I'm referring here to Rule 129X, sub 1, sub C, Roman 2, which requires that the independent panel, once established, must without delay provide the office bearer with copies of all the information available to the relating to the assessment. That will obviously include the motion and the evidence attached to it. And then C3 adds that the panel must provide the office bearer with a reasonable opportunity to respond in writing to all relevant allegations against them. Now, this must obviously include the right to object to the content of the motion. For instance, to say this allegation does not, even if true, does not sustain a charge of incompetence or misconduct as defined. And the last point that we would make is that what this really amounts to is a claim that a Chapter 9 office bearer is entitled to a hearing before an investigation is undertaken. The preliminary investigation by the independent panel, and then if the motion goes so far, the investigation by the Section 194 committee. But because the office bearer will have a right to be heard in both of those phases, this claim really amounts to a claim to a hearing before the taking of a step which will initiate an investigation, which in this case would be the constitution of the independent panel. And that, with respect, is something that our law hasn't recognized. We refer in this regard to the case of Langer, CJ, and others, v. Schlope, 2019, volume 4, SA 382 SCA at paragraph 40, and the authorities discussed there, as well as the other cases which are cited by the DA and its heads at page 37 in para 109. This brings me to the second ground of cross-appeal with which I will deal. It's under the heading Audi Alterum Partem. You make 2 points in this regard only. The first is that she makes very skeletal allegations in her answering affidavit regarding what she calls, and I quote, a generic ground of the unconstitutionality of the rules based on their breach of the Audi Alterum Partem rule, and the speaker's refusal to give reasons on demand. I'm referring here to volume 9, 884, page 884, paragraphs 125 to 127. We've addressed them in our heads at pages 38 to 41, paragraphs 93 to 104. And we point out that, as I've checked their heads again, our colleagues for Advocate Mkhwebane do not advance any argument in support of this challenge in the relevant part of their heads, which is pages 30 to 32, paragraphs 99 to 105. And so we infer that they've abandoned the points. And if we're wrong about that, we will deal with whatever is submitted in orally today in reply. That then brings me to the fourth topic, which goes to the order of severance which the High Court made. It's dealt with in our written submissions at pages 45, paragraphs 118 to 120. As this court knows, our basic submission rests on this court's judgment in the early case of Kutsia and the government, Matiso and the commanding officer, PE Prison, 1995, volume 4, SA 631, Constitutional Court, paragraph 16. We submit that the court was right, that if the High Court was right in its findings of unconstitutionality in relation to these two rules, 1929V and 129AD3, then severance of the affected portions of each rule is clearly appropriate. We refer also in this regard to the case of Van Rooyen and the State, 2002, volume 5, SA 246, Constitutional Court at paragraph 88, and specifically this court's holding that if legislation is found to be unconstitutional, then, if possible, the appropriate remedy should be in the form of a notional or actual severance or a reading in, so as to bring the law within acceptable constitutional standards. Only if this isn't possible must a declaration of complete invalidity be made. Now, in this case, severance is the obvious remedy for the constitutional defects. What will remain is not dependent on the severed portions, and it will give effect to the main objectives of the rules. In the case of rule of the one concerning the independent panel, they are the establishment of that panel to determine whether the charges are supported by prima facie evidence and to make recommendations to the Assembly. In the case of the Section 194 committee, that is affording the Chapter 9 office bearer the right to be heard in their defense and to be assisted by a legal practitioner or other expert. May I just add something about the last point? I find it very hard to understand how there can be any objection to the severance of the proviso to 129 AD3, because the main argument raised against us is that there should be no proviso. The rule should read as it reads in the case of the one concerning impeachment inquiries into the president. That brings me lastly to our colleagues' submission in paragraph 130 on page 39 of their written submissions, that the severance ordered by the High Court is inconsistent with the separation of powers because it entailed the court rewriting the rules of the National Assembly. Our answer to that is that there's no question of that happening here. This is a case of limited severance, leaving behind everything else which the Assembly has done, including and will achieve the purposes of the Assembly in making the rules. Then there is a ground of review headed reviewability. With respect, a curious point. We deal with it in our heads of argument or submissions at page 46, paras 121 to 123. The argument as we understand it is the following. Once the High Court rejected her attacks on the new rules, it was obliged to consider whether any of the grounds of attack rendered the Speaker's conduct taken pursuant to the new rules reviewable. And we see that volume 9, page 886, paras 137 to 139, and also in her council submissions at page 41, paragraphs 136 to 137. And I'd just like to illustrate why we submit this as curious with reference to the first ground that I dealt with, procedural irrationality. So the High Court held there was nothing procedurally irrational in the rules omission of a right to a hearing for the Chapter 9 office bearer before the Speaker decides whether a motion for their removal from office is in order. So the argument now is, well, having rejected that, one must now ascertain whether the Speaker's conduct taken pursuant to the rule was reviewable. But this shows the fundamental difficulty with this. Ms. Medise, when dealing with that, acted in accordance with the rules. She considered the motion and decided it was in order, and then appointed an independent panel and referred the motion and supporting to evidence to it for consideration. Once she got the panel's report, she referred it to the Assembly for its consideration. And after the Assembly had resolved that a Section 194 inquiry be proceeded with, she appointed the members of that committee. So it seems to me fatal to this argument that once the rules are found to be regular and the court sees that what the Speaker did was act in accordance with the rules, there can be no basis for finding that the High Court did not deal with something it ought to have dealt with.
Mr. Breitenbach, it's exactly 20 minutes.
Thank you. I have two issues to deal with, and I'm going to reserve one of them for reply, which is the claim for personal and punitive costs against the former Speaker. The reason being that I'd like to hear what my learned friend has to add to the very skeletal averments. All that I then wish to deal with is the proper order should any of Advocate Mkhwebani's further grounds of challenge to the new rules be upheld. We submit that in that eventuality,
3 minutes for that.
1 minute, Justice
Thank you
Madlang.
very much. Thank you very much.
In addition to making the requisite declaration of invalidity under section 172(1)(a), in line with her amended notice of motion, I'm referring to paragraph 4 on page 2 of volume 1, the court should grant an order in terms of 172(1)(b)(2), suspending the declaration of invalidity for a period of 6 months. This will achieve 3 just and equitable outcomes. The first is it will avoid the invalidation of the steps taken under the new rules since 3 December in the impeachment proceedings against her, something which my learned friend Mr. Bandanda will be addressing in the context of 129V. Secondly, it will allow the Assembly to correct the defects. And thirdly, it will avoid a lacuna while the Assembly is busy doing so. Obviously, should the nature of the ground upheld require amendments to the rule in the meantime, such as this court has made in many instances, for instance, in the Prince case, then it will do so. Those for now then our submissions. Thank you, Justice Madlanka and Justices of the Court.
Thank you, Mr. Breitenbach. Colleagues, I propose that to avoid a stop-start, that we take the adjournment now and resume at 11:19. And let's all join or rejoin the meeting before that, please, so that exactly at 11:19 we start.
Thank you, Justice Madlanga.
You're on mute, Mr. Venter.
Court will adjourn until 11:19. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 11:19. Should you exit, you may use the same link to rejoin the hearing.
In the conferral of powers on officials. It's like the uniform rules of court confer a host of authorities on judges, which you will not find in any other legislation. They come from the rules.
No, there's no such, you can't derive the power from the impugned rules. That is what Justice Madlanga, I think in Amabungane, was trying to explain, that there might be an implied power. That's a different topic. But to think that the power, for example, can come from the impugned rules is as I say, is just logically unsustainable. Because
so does that have the effect that no statute other than the Constitution itself can confer a power on anybody? Because you say, just listen to my question. You say if you attack the statute, then nobody can say, well, I get the power from the statute. You say, no, but I'm attacking the statute, so you can't get your power from the statute.
Exactly.
So on that footing, nobody can get any power unless it can be traced directly to the Constitution.
No. That's not what I'm saying. I'm saying something less than that. I'm saying that unless the statute, if you don't attack the statute, then what you are putting to me would be correct. In other words, if you don't say that the statute itself is unconstitutional, then you can then say, well, I don't know where the power derives from. But if the very business why we're here is to attack the constitutionality of the statute, let's say, then you can source the very power that is under attack from the attacked thing. So same as the uniform rules of court. If I come to court and I say, I'm now here to attack rule 25 or whatever of the uniform rules of court, then the court can say, well, but the power comes from rule 25 of the uniform rules of court. Because
but what can be said is that the rule is falls within the ambit of the matters on which the rule board can make rules.
Yes.
So the question is it within the power of the National Assembly to adopt rules which allows the Speaker, for example, to make appointments to a panel? Is it possible for the National Assembly to make rules to appoint committees?
No, let's go to the source of the power that has been alleged here, which is section 57. That, what you're asking me, read together with what Mr. Breitenbach's answer was, is allegedly derived from section 57 B, 1B of the Constitution, which says that the National Assembly may make rules and orders concerning its business with due regard to the representative and participatory democracy, accountability, transparency, and public involvement. But I'm just saying that that can never be an answer, because then the whole case of EFF impeachment, it means it was a waste of time. Because that section 57(1)(b) is pregnant with the fact that those rules must be constitutional and fair. It can't be giving to the National Assembly the right to make rules which are sexist, for argument's sake, because and then the National Assembly will say, no, we know that they're sexist, but remember we have a power under section 57(1)(b) to make any old rules that we like. No, it's inherent in that power that those rules must be constitutional, just as it is inherent in the uniform rules of court that the rule must be constitutional, just as it is inherent in a power derived from statute that that statute must be constitutional. Once you remove that assumption, then the whole house of cards falls apart. Because
so do you say it's inherent in the rule-making power that the Speaker could be given the power to appoint non-judges to the panel?
Sorry, I didn't get that.
Do you say it's inherent in the rule-making power of the National Assembly that they could make a rule allowing the Speaker to appoint non-judges to the panel?
Non-judges, yes. I'm saying
now, where does that power come from?
Because it comes from section, because that is not unconstitutional. It comes from section 57(1)(b). You understand? The power in section, for example, the Speaker could appoint an accountant to check their books. That power, or even Parliament could have appoint all sorts of people. But at the point of unconstitutionality, that's why I'm saying, assume that the Speaker, because of that, then makes a rule that is sexist. Then you say she cannot have a power to act unconstitutionally. That's why it's a secular...
but that then begs the question. You say it's constitutional for her to have the power to appoint non-judges to the panel, but it's unconstitutional for her to have the power to appoint a judge to the panel. That must depend on the answer to the question whether it is permissible for a judge to serve on this type of panel, the separation of powers point. It is that on which the constitutionality depends. It's not, it's not an ultra vires point. The power exists in the rules, and the question is whether such a rule is valid, given the separation of powers point.
Okay, look, all right, I'll leave it at that, but the point I'm making is that as we pleaded this in the just 1 second. At page 457, which is volume 5, the other side must meet the test, the case that is presented to them, not another case that is shorter than that. The heading, you see the heading at page 457. It says, separation of powers and ultra vires. In other words, the pleading, the point that was being presented to the other side was a dual point. Let me put it that way. The first was separation of powers, which you've correctly summarized, Justice Rogers. But there was a self-standing ultra-virus attack, which says, let's assume that maybe let's put it this way. The separation of powers point looks at the judge, okay? But the ultra-virus point looks at the speaker. What do I mean by that? The ultra-virus point says that, does the speaker herself have the virus, the powers to appoint a judge, and either she has or she doesn't. And that power must derive from somewhere. That's the simple point I'm making. And if it is not deriving from anywhere, except the very rules that are being attacked, then it doesn't derive anywhere. Because
carry on.
No, so I'm making 2 points. Sorry, Justice Rogers. I'll come back to you now. I just want to say the ultra-virus point must not be conflated with the separation of powers point, because that's where the mistake happens. And that is why because it might, let's say, for example, there was a power somewhere in the Constitution that says you may appoint a judge as the speaker. That would not deprive us of the separation of points of powers point, which is a completely separate point. I know they are related, but they are conceptually different points. And that's why we bleeded it like that. But sorry, Justice Rogers.
No, I think I've taken up enough time. I'll leave it there.
Mr. Mpofu, on this point, just for clarity, 129V2 is not under attack. Am I correct? The one that specifically says the speaker must appoint the panel.
No, it is. That's the ultra-virus point. Because we're saying that the mere fact that it says, I mean, it could say Mr. Mpofu must appoint the judge. And then the question would be, where does Mr. Mpofu derive the power to designate the judge? And the answer is nowhere, except if you use Justice Rogers' thing, it would say, well, he derives it from the very point rule that is under attack. It can't obviously work that way. And that's why I'm using the example of a commission of inquiry. If somebody came here and said, Justice, the DCJ Zondo, there's a so-called ultra-virus point, and it says, where did he get the power to chair the commission? The obvious answer would be, he got it from section 84(2)(f). Similarly, in Heath, if that person, Judge Heath, somebody said, where did Judge Heath get the power to head up that SIU unit? The answer to that was that he gets it from the SIU Act, or whatever it's called. But that was the very act that was under attack. So that could never have been an answer in the Heath case to say, no, but you can't attack Judge Heath's or rather the power of appointment, like it was even in Amabungane, because the very case in the RICA Act in the Amabungane case conferred the power for designating a judge. But that's not how you ask the question. The question is asked as to where in our constitutional scheme does Mr. Mpofu or the speaker or whoever derive a power to appoint X, Y, or Z?
I thought you did not have a problem with the appointment of other members of the panel. Your concern is the appointment of a judge. So 129V2 would be fine. That is, so far as the power of the speaker to appoint a panel that does not consist of a judge.
I don't know, Justice Mhlanga. It may be fine or not fine, but we're here about the appointment of a judge. That's all we are attacking. Whether to appoint all sorts of other people, she may be empowered. I have no view on that matter. I'm simply saying, insofar as that V2 grants her the power to appoint a judge, that's where we draw the line. So and that's what, but it's important crucially important to distinguish that, what I call the ultra virus point, from
but V2, if one accepts that she has the power to appoint, when it comes to the appointment of the judge, one has to have regard to V3, which says she must do so in consultation with the Chief Justice.
Yes, but by the time you get there, the whole thing is dead. Because if she, even V3 says that she is the appointing body, but she must do so in consultation with the Chief Justice. So it doesn't assist in our submission at the very least, Justice Mhlanga, that's actually aggravation. And I think Justice Majid raised that point in a different formulation. So the mere fact that you now want to involve the Chief Justice of the country in this ultra-virus act is aggravation, not mitigation. Because even if you read V3 properly, you will see that it retains the fact that the actual appointing person is the speaker. Granted that she does so in consultation with the Chief Justice. And let's say, for argument's sake, we accept my learned friend's argument that therefore makes it a joint appointment. But that joint appointment is what we are attacking. The mere fact that the joint appointment includes a person who doesn't have the title to appoint it taints the appointment process irretrievably. That's number one. Number two, Justice Mhlanga, to show that by the time we got to V3, the whole thing is actually out of the window. You related to the other point which was raised by one of the justices about and the court, by the way, the court about the political controversy point, to paraphrase it. You must remember that this whole thing is rotten from the conception, because this judge firstly is nominated by a political party by decree, right? Not even in the JSC process is that kind of thing allowed. I mean, imagine if a judge would to be appointed by a political party, but so this is what happens here. The judge is nominated long before we get to the speaker by a political party. Then the political party, rather, I'm sorry, the speaker in some secret room shortlist, let's assume. Let's say there are 13 parties in parliament now. Let's say all 13 of them nominated Judge A, or let's say there are 9. And each political party said the one appointed Justice Mpofu, let's say, and the other one Justice this one and Justice that one. Then the speaker, as I say, in some dark room, decides that no, I don't want Justice X or Justice Y. I'm going to maybe shortlist 3 of the justices. And then she appoints from her own shortlist the one judge who was nominated by a political party. And then, remember, the speaker is herself, in our system, she's a political being as well, because she's nominated or appointed from members of parliament. So we have a nomination by a political party, shortlisting by the speaker, who is a member of a political party, and then the whole thing goes to the National Assembly and is subjected to a 2/3 majority, which is politically derived. So at every given stage of this so-called appointment, it's what you call the fruits of a poison tree. Once and that's what the Concourt was at pains to point out, to say, then that judge will be called, this is the DA judge. I mean, to make it worse or to illustrate this point, think of this situation. Let's assume the DA was the ruling party. So the DA would have been the complainant. And then the DA speaker of parliament would then shortlist, do all the things that she has to do in darkness without all of us knowing, and then appoint the DA judge, quote unquote, the judge that was nominated by the DA. And then it goes to Parliament, and then the DA majority, and again, for the sake of emphasis, let's say the DA in that example had 2/3 majority. The DA 2/3, I mean, really, the flow, which started from the very political nomination, would simply permeate right through that process. And that is what is wrong with this picture, because we don't even know how. So by the time the Chief Justice, which is the short answer to you, Justice Nhlanhla, by the time the Chief Justice is quote unquote consulted, there's already one name. And how can you then say that the Chief Justice is a participant in this rotten or tainted nomination shortlisting process? All those stages are done politically or in secret until the Chief Justice is called to say, oh, well, do you have any objection for that Judge X, who is the DA judge or the ANC judge or the whatever judge? And the Chief Justice, the involvement of the Chief Justice with respect, Justice Nhlanhla, is purely administrative. And the Chief Justice will say, well, that judge is busy in a long criminal trial, and therefore I won't release them. Or, no, that judge is available. That has got nothing to do with the defects that were identified by the court accord in this entire business. But the reason why I'm spending more time on this is the following, is because it kills two birds with one stone, presumably. So when I deal with the grounds for cross appeal, I will not deal again with the ultra virus point, because we've already debated it. But if the ultra virus point is good as an attack, it's obviously it also means that the court accord should have upheld it. So that's self-evident. And by the way, something that the court may not know, because maybe it's not clear, but I'm sure I can say this from the bar, and if my learned friends think that I'm overstepping, they can say so. The High Court did exactly that which Justice Madlanga said should have been done in the Amabungane, because there was a complaint, which was unfounded, by the way, that the ultra virus point was raised for the first time in the High Court. That's clearly not true if you look at page 457. But let's say that was true. The court then gave the parties leave to file extra heads of argument and address the so-called new point. I mean, there was no new point, but it was addressed ad nauseum, both in the papers and in the heads before you. Here, it's even better because it's even separated out as a ground of cross appeal, so there can be no confusion. Now, the point here is that, of course, I think for all the cases, in fact, let's go to base one. The parties are ad idem, as Mr. Breitenbach explained, that this is a non-judicial function. So section A of the 4-stage test that Zondo DCJ set out in NSPCA, in the NSPCA case. So I'm sorry, it's summarized somewhere in the judgment. I'm trying to that section. Yes, I'll come to it now. Yeah. Judgment is 661.
Yes, at 690, 690, volume 7, let's call it the NSPCA test is correctly summarized there. And that was the test on which we based the representations. And it's very simple. It says A, the test is simple, put by this court. A, whether the performance of the whether the function complained of is a non-judicial function. And I'm saying that these appellants have considered that point, that is a non-judicial function. And then B, the next question is whether the performance of the non-judicial function by a member of the judiciary is expressly provided in the Constitution, which is the point I was debating with Justice Rogers. And it's considered here as well that no, it doesn't come from anywhere, not in the Constitution and not even in legislation in this case. And then comes the third question, which is the real question here in this case. Whether the non-judicial function is closely connected with the core function of the judiciary. Now let's pause there. The answer to that third question is a definite no for the following reason. One, I've already said that the judges and their core function of judges is not, I'm sorry to say to do this again, but it is the connection that was drawn by Justice Majid between these two things. Judges do not have as their core function presiding over proceedings where legal representation is denied, okay, for starters, yeah. But the real question about that is the real answer, or the second answer, is the one that Justice Madlanga posed, which we pose both in our affidavit, but also in our heads. And it's a rhetorical question, but the answer is obvious. It is this: if the involvement of the judge is so essential and, quote, closely connected with the core function of the judiciary, then why does the 129V make it optional? Why does it use the word may? Because I mean, it's just logic. If it was so core, then it would say the three-person must include a judge. In fact, it should even say all three of them should be judges. But the mere fact that it makes it optional is the clearest, as Justice Madlanga asked and was not answered, is the clearest example of the fact that it is a nice to do. You know, it's something that you may do. But the second point related to Justice Madlanga's point is that the judge is one of three people. So the judge can be overruled by the other two. So that's the clearest, another clearest example to show that the involvement of a judge is just a nice optional extra. And I'm the last one to, sorry, Justice Madlanga, I'm the last one to quibble against the point made by my learned friends and even the amici, that the inclusion of a judge kind of, what do they say, enhances the stature of the panel. No, that's not the question. The question is before the state.
The 30 minutes is up, Mr. Bof.
Justice Madlanga. Okay, now we can talk about.
I did not want to stop you mid-sentence, but I saw that you are going on. Yeah. How much more time do you want, Mr. Bof?
Well, I would say, because I still have to deal with the relief, half an hour.
Half an hour. All right, I'll give it to you. But yes, that will be the ultimate terminal point, Mr. Mpofu. So please try to make it within that. And I'm just thinking that I must give an explanation for the viewers. Misperceptions easily get created because you indicated that At the private session I had with counsel, I gave you more time. So people may be wondering why.
Yes. What is this private session?
And there will be no explanation. Well, this was a session with all counsel involved in the matter.
Of course.
And the reason for Mr. Mpofu being given more time is because he is responding to 3 counsel. You may continue, Mr. Mpofu.
Thank you, Justice Matanga. Yes, yeah, no, it only meant the other judges were not in that session. But yes, I think you're right, these things. Well, on that point of misperceptions, that's exactly the point that is made by the Concourt, by the way, because they say that in this day and age where there are misperceptions about judges, I think I don't know if it's I hope I'm not confusing it with another case, but there's a case where it was said that judges are sometimes accused of siding with political parties or even factions. I think it was this case. Yes. Now, if you accept that as an obvious South African reality, unfortunate reality, but one that is out there, then imagine if they say, okay, this is the ACDP judge, I'll use my Leonard Jr., Judge Shabalala. He's the ACDP judge who was appointed by the ACDP speaker. And then next week, he sits in a case of the ACDP versus some municipal council. And then, lo and behold, he finds in favor of the ACDP correctly, without anything wrong. How can you fault the public from saying, oh, well, what did you expect from the ACDP judge? Because he's the one who was nominated by the ACDP from a pool of 500, okay, of 50 judges. He was then handpicked by the ACDP speaker. And now the following week, he's presiding over the ACDP case. And you expect him to find otherwise, you must be smoking something. Now, that perception might be completely wrong, as we know, because the judge might have just applied the facts to the law and so on. But it's exactly as Justice Matanga was constrained to have to explain, because this is not just a private business. We're all answerable to the public out there. But it just emphasizes the point. So let me quickly go, having addressed the separation of powers point together with its cousin, which I call the ultra-virus point, which also features in the cross-appeal matters. Then I go to the conditional cross-appeal. As I said, without repeating this point, let's assume the first ground of cross-appeal is this ultra-virus point. So if the appeal can succeed even only on this point of whether the speaker has the power to appoint or not, then the cross-appeal must succeed, full stop. The fact that it might only succeed for one of the 5 grounds asserted is neither here nor there. But we go and say that the cross-appeal must also succeed for other reasons. And one of those reasons is the retrospectivity. If I may, because I don't have time, please allow me again to do another coupling, let me call it. So let's couple the retrospectivity point with the other point about definitions, about whether Section 194 has been widened by the rules. And you'll see the importance of coupling those two things because they are interrelated. One, everybody accepts that retrospectivity is an aspect of the rule of law. This court made that point in Pasha. sorry, I'll find the reference now. That the nulla povena sine lege rule is codified, as I was explaining later, in the rule of law, and therefore the presumption against retrospectivity is an incident of that. That's right. I don't think anybody will quibble with the fact that it is against the rule of law for somebody to be punished for a law that did not exist at the time of its promulgation. Now, the one of the exceptions to that rule is, which the other side seeks to invoke, is the fact that even it's a dubious exception in its own right, but for now, let's say it is an exception, is that it doesn't apply to procedural if the enactment that is being attacked is merely procedural. And you'll see in LOSA volume 25, paragraph 329, it is even says, it is doubtful whether this quote unquote procedural exception to the principal presumption against retrospectivity is a real exception, in the sense that it provides for true retroaction of procedural provisions. But notwithstanding that qualification, let's, for the present purposes, assume that it's a proper exception. I'm saying that that exception cannot apply in this case for the following reason. The rules that are being attacked do not even pretend to be purely procedural, because they go to define the offenses. Let's call it like that. There's nobody in their right mind who can argue that a definition of the offense is a procedural matter. That's clearly a matter of substance. And that's why I'm saying these 2 points are related. These rules, the rules that are being attacked are, yes, they are procedural, but they are also substantive in the sense that they don't confine themselves to procedural issues, but they deal with issues of substance, such as defining the offenses, quote unquote, right? Now, if we accept that at worst, we're dealing with a hybrid type of rules here, which have a procedural element, and I'm prepared to concede that the procedural element is the dominant element, but which nevertheless have a substantive element to them. Then here's the quagmire, which goes to the root of the presumption against retrospectivity, if you look at its constitutional foundations. Let us say, and again, if the court will give me some leeway here, let us say the rules said you'll be impeached for these 5 things: misconduct, incompetence, incapacity, and taking your long leave to be too long, or whatever. Then nobody would argue against the following proposition, that Parliament has no power, virus, to expand the definitions of the offenses beyond those which have been set by the Constitution. Anybody, even a first-year student, would agree to that, that the Parliament could not add, without amending the Constitution, add another transgression, however advisable or inadvisable it is. If they thought, oh no, you know, the founders of the Constitution just forgot about, there's this whole thing about abusing long leave or whatever. And you can't. Why? Because the power cannot extend. So the sole question really is this. My learned friend, Mr. Breitenbach, is 100% correct that in the EFF impeachment case, it was said that the National Assembly has the right, let's call it like that, or even the power, to spell out the rules. But there's a big difference between spelling out something and expanding it, or for that matter, even narrowing it, as Mr. Breitenbach says, no. I'm not sure if that's Mr. Breitenbach or Mr. Padlender. They say, no, well, she can't complain because actually the definition of gross negligence narrows the scope. But who said that Parliament has a right to narrow the scope? So they have no right to amend the rule expansively or so as to narrow it. It's not their business. They don't have that power. So so here comes the real retrospectivity point. Again, indulge me and assume for a minute that the rules do expand the definition. Then it goes to the heartland of the objection against retrospectivity, because it means it is theoretically possible to apply these rules for this new transgression or the extended transgression, which did not exist until the 3rd of December 2019. In other words, until the expansion of the definition by Parliament, what this thing was not an offense. But now you want to apply rules which came on that date to charge you for that thing that was legal, completely legal, up to the 2nd of December. So clearly, the rule against retrospectivity read together with the issue of the expansion of the definition is offended, which then begs the following question: is the definition expanded as we contend, or is it not expanded as Mr. Breitenbach contends not? Here's the point. You can't use semantics here. The point of the matter is whether these rules can be interpreted now to include the following situation. And again, I'll be exaggerating for effect. That a condition which is a temporary condition can be used to impeach a head of a Section 9 institution, and a judge for that matter. Because remember, under Section 177, incapacity is also one of the grounds. So it really means that if a judge, and again, forgive me for exaggerating for effect, if a judge catches COVID or breaks a leg or whatever, and is temporarily incapacitated, then that's an impeachable offense. Surely that's just an absurdity. It's actually nonsensical to even imagine such a thing. So once you expand, restrict, or whatever, the definition to include even temporary conditions, which are not spelled out in the Constitution, then it means by so doing, you are not spelling out. You've gone beyond the realm of spelling out, which is what the Constitutional Court said you can do in EFF impeachment. You are now adding new offenses, which did not exist before the 3rd of December 2019. Now, if we accept that, and it's the same, by the way, with the misconduct definition. It's short comfort to say no. Now, if you say negligence is enough, you are actually helping the person. It's like saying to someone, well, murder is a crime of intention, but if we now amend it to only be based on negligence, we're helping you, so you can't complain. It can't be like that. The mere fact that you are now restricting it to negligence, the only point I'm making is that you are amending it. Whether you're amending it, whether it's a good amendment for you or a bad one is irrelevant. An amendment is not allowed either way. So the rules are unconstitutional for that reason alone of retrospectivity. Then let's go to, I won't go to the issues of severance and reviewability and so on. We'll just remain with what is in our heads. And the reason for that is because I'm running out of time and I can't not make this point. This point is the where I say Mr. Badlander, well, I can forgive him for the first part, to say maybe it's an inadvertent misrepresentation. But the second one is either deliberate or willful blindness. He says that our complaint about the remedy point being raised for the first time here is unfounded because it was raised by...
Mr. Mpofu, I can see that you are moving away from retrospectivity.
Yes.
May I just remind you, can you please assist me with the question I had posed and Mr. Badlander deferred to you about the retrospectivity of the rules, whether they apply to all that you are submitting, that the limitation of retrospectivity should apply to all heads of Chapter 9 institutions, or whether your submission only relates to the complaint, the present complaint against the public protector.
Thank you, Justice Chikwe, because by that question actually helps me to sneak in the point about reviewability. No, we must distinguish between two things. The first point, which is the constitutionality point, relates to everybody, including other Chapter 9 heads. As I've said, it goes even further. It even includes judges or anybody else. And that point is simply this. You cannot, whether you are the public protector or the AG or whatever, you can't suddenly find yourself in jeopardy of being impeached for temporary incapacity. And I'm using that generically, temporary condition, the equivalent about whether it's temporary incapacity or temporary condition. I don't care, let's use both. You can't now find yourself suddenly in jeopardy of being impeachable by a temporary condition, which was not the case before the 3rd of December. That complaint has got nothing to do with whether you are the head of the religious institution or the IEC or the AG or the public protector. So that's the first answer. The second answer is that, so retrospectivity the second point is the one I made, that if that is so for the Chapter 9 institutions, why is it not so for judges? Because the Constitution again uses the word incapacity. So if some person, even Parliament for that matter, remember the impeachment of judges is regulated by the Judicial Services Act. So Parliament could not, for example, come up and pass the Judicial Services Act that says judges must be impeached for a temporary condition. Because by so doing, that provision would be unconstitutional, because it would be expanding the constitutional offense of incapacity to now suddenly include breaking of ankles and all sorts of the flu, and so on. And that's how you test this thing. You don't test it by doing what Mr. Badlander or Mr. Breitenbach was saying, of saying, well, in certain cases, it will be so, the transgression will be so large that that distinction doesn't matter. No, you must look at the ridiculous, so to speak, of whether so-called temporary incapacity is just the common flu.
Sorry, Mr. Mpofu.
Okay.
Can I just find out from you, before these rules were drafted, were there any rules that regulated the process within which the National Assembly could impeach heads of Chapter 9 institutions?
No.
The reason I'm asking that question is because you're now trying to compare it with the process that regulates the impeachment of judges. And maybe I'm misunderstanding you there.
Yes.
Whether that comparison is fair at all.
Okay, let's forget about judges. Anybody, let's call the license inspectors of dog licenses. those people cannot be impeached for something that did not, if there's a rule that says you may not have 5 dogs in the same cage, they cannot, and you, otherwise you'll be impeached. They can't now be impeached with another rule that says you might not have 6 dogs, because that rule did not exist at the time of the, that's the pure retrospectivity point. It's got nothing to do with judges. I was just using it as an example to say that anybody under the sun cannot be punished for something that was not an offense at the time of the promulgation of the thing. So the use of the example of judges was just a useful facility. So the point I'm merely making now is that okay, well, that's enough.
Can I make a
going to the
follow-up
retrospectivity point? Yes, sorry, Justice.
Yes. Can I make a follow-up question? Could
yes,
before
yes,
the rules, yes, before
as long as Justice
rules,
Madanga will factor that in.
Before the rules were drafted, Mr. Mpofu, could the public protector or be impeached for misconduct?
For misconduct, no. For anything, she couldn't be impeached for anything. That's what the whole case called EFF impeachment case is, exactly that. In that case, I was arguing for the opposite contention, and the court correctly said no. Because in the impeachment case, I was saying you cannot allow a president who, even the Constitutional Court has said what they did in the Nkandla situation is misconduct. You can't let them get away with it simply because there were no rules for impeachment. And the court correctly said no, Mr. Mpofu. If there are no rules, and again, bracket what I said to Justice Mhlanga, if there are no lawful and constitutional rules, not any old rules that you can write at the back of a cigarette box, if there are no constitutionally valid rules, you cannot impeach the president. And that is why Parliament had to eat, and my client had to, which was the UDM, I think, had to eat humble pie and say, irrespective, and we were saying, look, go to paragraph, I think it's paragraph 83 of the Nkandla case. It says that this was the worst thing, an abuse of people's money, and Nkandla this, Nkandla that. And we said it's there, but they said no. Without the proper constitutionally valid rules, you cannot do it. And that's why the Section 89 rules were then designed. And the point I was making was, I was not making it facetiously. Those rules may or may not be constitutional. Maybe they are unconstitutional themselves for other reasons. But I'm prepared for the purposes of this discussion to assume that they are constitutional. Because remember, if they are unconstitutional, those rules, then we should just all go home. Because these rules here are mimicked on those rules. But that's another point. The short answer is no, there were no such rules. And this time, fortunately, Parliament did not even pretend, as it did in the impeachment case, that you could do it under the normal rules. May I move on to the retrospectivity point? Justice Madlang. Yeah. Right. Now, we have to be careful here because there's smoke and mirrors that have been. If you go to, firstly to the parts. Sorry, I think it's volume 5, where it's now said that this whole retrospectivity point is actually derived from the public protector's own pleadings. Well, you will see. Sorry. The notice of motion, supplementary notice of motion. Anyway, let me make the point because there's no time. Paragraph 4 of the Public Protector's amended notice of motion talks about the suspension of invalidity for 6 months. And Mr. Badlander says, coming from that paragraph, they all of a sudden now agree with us that that's what should happen. Well, let me show you how that is a complete adulteration of what was argued there. The confusion, the primary confusion is between the provisions of section 172(1)(b) Roman 1, which is the one that they want to assert now, and section 172(b) Roman 2, which is what was being spoken about by the Public Protector. And you'll find that at page 464, yes. Yes, page 464. This is where, and Mr. Badlander says, that prayer is never explained by the PP. Well, that's just untrue, because the prayer is explained at page 464, and I will demonstrate now that it is a reference to 172(b) Roman 2, not B1, which is the one that they are invoking. We say that the Public Protector says in her founding affidavit, I've been further advised that in terms of section 172 of the Constitution, when deciding a constitutional matter within its power, a court must declare, forget that, B may, that's, let's forget that for now, and subsection 1 also assume that it wasn't there for now. And here's the crux, the part that she underlines, emphasis added. She says, an order suspending the declaration of invalidity for any period and on any conditions to allow the competent authority to correct the defect. And that is now opportunistically being invoked as if to say the Public Protector was invoking B Roman 1. But let me show you why Mr. Badlander says it was never explained, which is just untrue. Paragraph 142 says, it is therefore my respectful submission that the Honorable Court should grant an order as praised in the notice of motion, including an order suspending the declaration of invalidity and remit the impugned rules to the National Assembly for redrafting, as well as drafting of the rules governing section 194. Strictly speaking, such relief is reserved for orders of statutory invalidity, but I'm advised that it will be argued that this is an appropriate case for the said remedy to be extended to an important instrument such as the rules for the lawful implementation or an impeachment in terms of section 194 of the Constitution. So what the Public Protector was saying was not what she's being accused falsely of having said. She did not say that there must be an order in terms of 172(1)(b). She was saying and that's the reason, by the way, this was abandoned in front of the High Court, because it was just didn't gel. We were talking here about the normal order, which is granted if you have a statutory invalidity order, and we considered, and as I concede now, that those orders are different from orders of invalidity of mere rules of court, rather rules of parliament. So nothing could be further from the truth. So firstly, this is introduced surreptitiously and falsely and wrongly to escape the reality that they did not raise the issue of 172(1)(b) Roman 1 in the court of quo. and want to raise it here for the first time. To escape that difficulty, they then lump it onto the public protector to say, no, this is her point. But let's say for argument's sake, it was her point. If it was her point, then it means it was overruled by the court accord. It means the court found against us on that point. So now it means the speaker and the DA are now appealing for the public protector of her point that was rejected. I mean, what is that? It would mean that they suddenly embrace a point that we argued unsuccessfully. I don't even want to explain how that is just illogical. Yeah. But the point of the matter is that we were referring, as explained in paragraph 142, to a completely different animal, which is found in section 172B, Roman 2, or at worst, 172(2). If you go to 172(2) of the and I'll explain now actually what we're trying to do there, and that's why it was abandoned, because it was ill-advised. 172(2)B talks about a court which makes an order of constitutional invalidity may grant a temporary interdict or other temporary relief to a party, or may adjourn the proceedings pending the decision of the Constitutional Court on the validity of that act or conduct. That's why we were making reference to the invalidity of legislation. What we were trying to do, I can confess now, in that section, was to...
As you confess, Mr. Mpofu, the further additional 30 minutes is up. How much more time do you require to wrap up? To please...
10. Just 10, Justice Matlang. Or 15 if you're in a good mood.
No, I'm not.
Okay, 10 minutes will be enough. All right. No, and I'll try to, as it won't be a target. I'll try to do it before. Because this is now, we're just talking about relief. Okay, let me finish this point because there's another point. Let me write it down so that I don't forget. Right. Let me finish this point. The point here is that what we were trying to do, if you go to that page 464 that I referred the court to, okay, maybe it's not here, maybe it's in the reply. What we're trying to do, and as I say, it became clear even to us that it had to be abandoned. We were saying that this court, or not this court, the Cape High Court could, in a way, undo the judgment of Saldanha, J, and others in Part A, a la Section 172(2)B. And you'll see in reply, we even say, if new facts come into light in the full court, that court would be entitled, in terms of Section 172(1)B(1) or 172, to grant an order that said the following: these orders are rules are unconstitutional, and therefore you may not proceed with the process in Parliament because of the same reasons we had argued in. So it was an ill-fated attempt, if you like, to reintroduce the interim order through the back door. And that's why we abandoned that effort, because it was wrong. And now they want to revive it like the biblical Lazarus and brush it up and invoke it against us to escape the consequences of a direct access point. We abandoned it. It was never argued by us in the other court because it's a bad point, and it was the court did not even consider it. So it is a pure situation of it being raised for the first time before you, which on the authority of S versus Ntsele and Melo should not be done. But there's no Mr. Badlander must try another one. And by the way, in his, it's just that because I don't have time now, he referred the court to the answering affidavit where they were meeting this point. You'll find in that paragraph, they specifically say that we assume that the public protector is invoking 172(1)(b) Roman 1. And that assumption has no basis, as I've just explained now. He'll probably give you the page number, but that's what they said. So there's no confusion about which part of 172 was being invoked and which part is now being invoked for the first time. The last point, Justice Madlanga, before I run out of the injury time, is this. Whatever this issue, let's assume for argument's sake now, that this court found itself without anybody motivating for it, just in a good mood to grant direct access on this point. Then, even in those circumstances, the following would have to be taken into account: that there is a dynamic relationship between the dynamics of the case and the relief. And I'll explain what I mean by that. So if for argument's sake, you are with us on the retrospectivity point, I'm just choosing a point at random, or on the appointment point, which is the ultra-virus point, then ipso facto, the kind of relief that might be granted must take into account that these rules have now been declared to be unconstitutional, actually for additional grounds than those that were identified by the Cape High Court. So in which world then can the court say, Mr. Mpofu, yeah, firstly, we are dismissing I'm being optimistic, I know. We are dismissing both the legal representation point and the misrepresentation, rather separation of powers point of the appellants. And what is more, we're upholding your retrospectivity point and your other points, whatever, of cross appeal. But having now actually said these rules are even more unconstitutional than the High Court, we're saying in the same breath that for the first time, without anyone having argued it or being given an opportunity to, it must, the retrospectivity is reversed. I mean, there's just no possible way. Now, I know, of course, the counter to that would be, well, there are so many permutations. It might be that you uphold the appeal and reject, or uphold the cross appeal and reject. And so I agree. But I'm using the most extreme example to drive the point home, to say that if actually there is more reason for unconstitutionality, then how can this court then say mero motu, unargued, direct access, that the rules are it's prospective, let alone the fact that we have taken the point separately that severance was not appropriate in these circumstances. Assume for a minute that we are right even about that. Then it means that the court, this court, forget the High Court, will be amending the rules. So we'll have court-made rules now. And next week, the public protector must face the ad hoc committee by rules that were either designed by the High Court in Cape Town or this court. That's separation of powers 101. That's why in all the cases about severance and reading in and all those things, it is said that the court must always be mindful of the separation of powers. This court, neither this court nor the High Court in Cape Town had actually the right to redo the rules for Parliament, because it's a separation of powers thing. the National Assembly, or rather Section 183, I think, of the Public Protectors Act says that the public protector should be impeached by the National Assembly. So does Section 194 say. There's no place where it says must be impeached by the National Assembly, aided by the judiciary, because that would be making a mockery of the separation of powers. So neither court has any right either to sever or replace or actually craft new rules, even if those rules are the best rules in the world. The public protector, and to come to Justice Chikli's point, any of the other Chapter 9 institutions cannot be tried next week in terms of those rules which are made by judges, as opposed to the elected representatives of the people in the National Assembly. So that's just, it's not done. So but the relationship between that and Justice Chikli's issue is that when it comes to these facts, Justice Chikli, we make the point that, assume for a minute we are completely wrong on unconstitutionality, on everything we have said. We are saying that we have pleaded that in any event, in this case, the conduct of the speaker, for example, in accepting the so-called in order finding, and the public protector just finding it in the newspaper like everyone else, that is reviewable. Quite apart from the fact that if it's true that the rule doesn't give you Audi, it's unconstitutional, but put that aside. Assume that the rule did give you Audi, but the speaker nevertheless decided not to inform you, and you're just driving home one day and on the billboard it says Justice Shabalala is going to be impeached. When the impeacher has not informed you, so it would be set aside for that reason alone, and various other grounds of review, irrespective of, in other words, on the facts of this case. So we must distinguish between the objective unconstitutionality, which is our primary attack, versus the subjective reviewability of the conduct in how this thing was done, including the fact that, yes.
Neither you nor your client can ever say that we did not give you a hearing.
No, I don't know about my client, but I certainly can't. Justice Madam, you were indebted to the court for the extra indulgence. Those are our submissions, very short and sweet, that the appeal must be dismissed, and the conditional cross appeals, if the appeal is upheld, must in any event be upheld. But the primary issue is that this must go to the SCA. It has no business wasting your time here. And the same rules that were applied in Kaunda and Commissioner for SARS must apply here.
Thank you, Mr. Mpofu.
With your leave, Justice Mudlanga. Mr. Mpofu, on the question of urgency,
yes,
does your client accept that there is an urgent need for Parliament to perform its functions in terms of Section 194, and that that this matter not being resolved will not enable Parliament to urgently perform their duties?
Yes, all cases are like that, Justice Teron, including the one that I argued before you. In fact, you were the one who raised this issue in the Commissioner for SARS matter, to say, Mr. Mpofu, assume you are right on everything. Why must we bypass the SCA? And I tried my best.
Let's deal with urgency as it relates to this matter, Mr. Mpofu.
Yes, well, okay. On the counter test, the two things are interrelated.
And the speaker deals with this in paragraphs 97 and 98 of her affidavit, which appear at page 766 of volume 8.
766 of volume 8.
Yes, yes.
Yeah. That's in the founding.
As you know, every matter must be dealt with on its own peculiar facts. And the speaker makes alleges why the matter is urgent. Paragraphs 97 to 98, page 766 at volume 8. And the speaker says there's some degree of urgency in Parliament being able to proceed in terms of Section 194. What do you say to that?
So what does that mean? There's some urgency in terms of Section 194. That would then mean all matters being dealt with under Section 194 are urgent. Of course, they are important and they must be done, but some urgency really cannot cut it, number one. Number two, once the respondent, and I take the point, Justice Theron, let's say they alluded to it in their founding affidavit. But like in the High Court, once the respondent now frontally attacks the issue of urgency as a point in limine, you can't A, say nothing about it in your replying affidavit, B, say nothing, zero, zilch, about it in your heads, C, say nothing about it in your argument in court. It's not done. How, when the respondent has now raised this issue of direct access agency and direct appeal as an issue, because they could have done this thing of some agency and then we ignore it. And then you would say, oh, well, you have acquiesced. So it's sufficient to just say some agency. But we went to town blow by blow, explaining that there's no agency, some or not some. There's no agency. And they did nothing until today. On those circumstances, it's the first time, at least in this court, it would be the first time that the court would nevertheless find agency, which the other side is so blasé about and doesn't even think is a matter that should be addressed.
Well, I suppose we would do what we normally do, Mr. Mpofu. We would have regard to all the facts and the law and see how we exercise our discretion.
Yes, but at least somebody must ask you to. That's all I'm saying. If someone says, justices, it's in the interest of justice for this and that reason, of course you'll do what you do every day. But it will, that's not what I'm saying will be the first time, because that happens every day. What will be the first time is that you do that unprovoked by anybody, without anyone having said that.
I'm not sure I understand your argument. I've just referred you to the speaker's affidavit where that's her case for urgency. The question would be, has she met the requirements for urgency?
Yes, Justice Theron, I've already addressed that. I'm saying it's not sufficient. Actually, it's meaningless. Maybe put it stronger for a party to give some throwaway sentence about some agency, and then when the respondent takes the issue, it's like if the court said, if they said, as parties always say, I have locus standi because I'm acting in the interest of the public, and then the respondents go to 10 pages to deal with the issue of locus standi, and then they don't deal with it in reply, they don't deal with it in their heads, they don't deal with it in court. And then we say, no, let's go to, remember in the founding affidavit, they made
I'm very mindful of time, Mr. Mpofu. Let me take you to section 172. Does the public, yes. Section 172, yeah, I see you looking at the papers, you can look at the Constitution, yes. Does the public protector accept that this court is empowered to make a just and equitable order when it comes to a declaration of invalidity?
Of course we do, but the point when we make it.
So does it matter who raised it or if any of the parties did not raise it?
Yes, it does. That's why if you go to page 14 of our heads, which is the Melo case and then Sila cases. It's Justice Krichler. That's exactly what Justice Krichler, or rather, no, it was Justice Mohoro in Melo said, that it depends largely on the evidence placed before the court. So somebody must place that evidence. But Justice Krichler took it further on the following page, S versus Ntsele, by saying where that is so, all the relevant, it says it's a very difficult, it presents difficult choices, as is borne out by several judgments of this court, which he cites. And then it says, where that is so, all the relevant evidence should be received for and evaluated by the court of first instance. So it does matter, because if it is received and evaluated, as he called it, by the court of last instance, it's not the same thing as if being received and evaluated by the court of first instance. So it matters a great deal. That's the answer.
I may have missed this, but what prejudice will the public protector suffer if the order regarding legal representation or any order is made retrospective? Oh, sorry, prospective.
Well, apart from the prejudice that is obviously inherent in the fact that that matter was not, would have been raised here for the first time, I would think that the prejudice there is self-evident, because she would have addressed it had it been raised in the High Court. But the second type of prejudice is that the sum total of such an order would be effectively saying that she must be impeached in terms of rules that are unconstitutional, that everyone accepts are unconstitutional in two major respects. And that's where the fruits of a poison 3 issue comes in. Because it would mean this, Justice Taron. It would mean that the current process, which is now at the ad hoc, it's common cause, at the ad hoc committee stage, which it would not have been there had the so-called Nkabinde panel not made a finding that there is a prima facie case. I accept my learned friends go on and on about the fact that the Nkabinde J panel's findings are recommendations. I'm not there. I'm simply saying, as a matter of fact, the Nkabinde J panel made a finding that there's prima facie evidence, as the rules prescribe. Then it was taken to Parliament. Then Parliament voted by the majority, which was the ANC and I think and the DA majority combined, that the current process should take place. So that process is the fruits of the poison 3, because that process comes from a panel that is tainted in two major respects: the separation of powers point and the ultra virus point. So to say what project, it's like saying I can be tried. Somebody can wake up and say, I'm drafting my new version of the Criminal Procedure Act. And then if I say, no, this is, you can't do that, let it be taken back to Parliament. So, well, in the meantime, you must face there's a new Criminal Procedure Act that says the death sentence is back. But so in the meantime, you must be subjected to it because you will not suffer any prejudice. No, it's inherent. The prejudice is inherent in the fact that the rules because remember the Section 89 problem, I think it was Justice Chick who asked this question, was exactly that the reason why you could not impeach a president was because there were no rules. We say that for shorthand. But what we really meant is that there are no constitutionally valid and lawful rules. So we're still in the same place. Why? I'm sorry, if I can I just finish that, just that sentence? Thank you, Justice. I'm saying, so we are in the same place now that we were in before this court adjudicated the EFF impeachment matter, where there are no constitutional rules. The fact that there's something on a piece of paper typed is irrelevant. There are no constitutionally valid rules. And therefore, until such time that there are constitutionally valid rules, you can't subject somebody to that. It would just be a kangaroo court.
You spoke about the recommendations made by the panel. is it accepted that the panel makes non-binding recommendations?
Yes, it is accepted, except with this caveat, Justice Taron. You can't nitpick the rules. You must look at the what you call a 17-stage process that is mapped out by the speaker, which we all accepted in the High Court. We all accepted that we are working on the basis of the 17-step process. Now, if you look at it then as that, then you will be constrained to accept that you would not get to stage 12. I can't remember what stage it is now. You would not get to stage 12 where we are now. Had stage 10, which is the Nkabinde panel, not done certain things. So
now,
yes,
on the non-binding nature of the recommendations, in Heath, at paragraph 32, this court held that it's permissible for the judges to give other branches advice on the administration of justice.
yes.
Would the report of that panel not count as advice as considered in Heath?
Okay, I can't see the connection between advice of that panel and advice that may be given or not given by a court of law. But assuming that let's call it the Heath standard were to be applied, this is the problem, that Parliament would still be implementing rules that are unconstitutional. That's number one. Number two, the rules that would then be implemented would, on everybody's version, be susceptible to alteration. Let me use a neutral word. And then comes number three, which is important, which is the permanent warning that is given to courts about severance and reading in, that it is not for the court to do that alteration. That alteration, particularly just in general, it's not for the court to do the alteration. How much more in a situation where the Constitution, no less than the Constitution, says that the accountability body is the National Assembly. So it's very clear that the judiciary and the executive are excluded explicitly from.
I'm dealing with the separation of powers point, Mr. Mpofu.
No, okay. I'm also dealing with the separation of powers point, but in relation to the relief, I thought we were discussing the relief. I'm saying the relief of the court changing the rules as it has purported to do, the High Court.
I was raising the status of the report and dealing with the recommendations and the non-binding nature of the recommendations that were made. And I drew your attention to paragraph 32 of Heath. And my question was whether the report of that panel and the non-binding recommendations they make would cover the kind of advice envisaged in Heath.
No, paragraph 32 of Heath deals with, well, it starts by some US examples and so on. And then it says that judges, the president of Council also referred to 178, which makes provision for judges to sit in the Judicial Service Commission, the majority of whose members are not judges. The commission has a central role in the appointment of judges and may. The functions of JSC are not consistent with the role of judiciary. I don't see where it says that judges may, or it says, yes, the appointment of judges is crucial to the functioning of independent courts. The giving of advice on the administration of justice is also related to the subject matter of the judicial office. Government is not bound by the advice given, and if the subject on which the advice is sought in connection, the judge's consent can decline to participate in the giving of such advice. No, that's a completely different discussion. That discussion is about the following phenomenon. It has nothing to do with the tainted so-called recommendation, which is what we're discussing.
Let me try cut to the chase, Mr. Mpofu. We're dealing with a judge being part of the panel and the advice of a judge being sought. That is what my question relates to. And he says that is perfectly in order. What is your comment about that in relation to the non-binding recommendations made by the panel in this matter?
Okay, I have two, well, one is a short one. The first answer is that that would not cure the defect, which I pointed out, that this thing was poisoned from inception. And that doesn't arise in Heath. It's assumed that we're talking about legitimate advice, if you know what I mean. If we're talking about advice that is validly sought and validly received. But here we're talking about quote unquote advice which is poisoned from inception. So it would not be an answer to the appointment point. In other words, that's why I said, if you are with me on the ultra-virus point, that's the end of it. Doesn't matter that they gave great advice thereafter if there is no constitutional power for him to be there in the first place. So,
I suppose your answer would be the same to the next question then. If the recommendations are non-binding and if it merely provides a view as to whether a prima facie case for removal has been made out, on what basis can your client then say there has been participation by the judge in the process of removal, which has the result of the judge usurping the powers of Parliament?
Because the process, the 17-step process must be seen as a whole. And if in the 17-step process, you are saying there should be no teachers or nurses, then you can't then say at a particular stage, let's unthink or let's write off the fact that the process was tainted ab initio. Yes, so sorry, I was just looking at a note. So yes, you're quite right, Justice Theron, your suspicion was correct, that the answer is the same. One cannot want to truncate the process conveniently so that we look at it in compartmentalized fashion. The process is all continuous. And if it is wrong for the speaker to usurp the powers of the JSC or whatever, or the powers of nobody, because I don't know which body can just wake up and appoint judges or designate them to do this or the other. So if she's wrong to do that, to simply wake up and say, I want Judge X, without any empowering provision, then one cannot then say, oh no, but it's just a recommendation. But it's a recommendation by an unlawful and unconstitutional panel. So it can be cured by the binding or non-binding nature thereof. Just like let's say the speaker, we find that no, the speaker who did this was not the right speaker. It was just some imposter. So you can then say, oh, well, but all she did was just, this imposter only said that the complaint was in order, but it was a non-binding thing. So let's let it continue because the imposter only gave a determination that is non-binding. No, you must look at the
Thank you. If I can go very briefly to the conditional cross appeal. What is the reason for this appeal being conditional?
Sorry?
Why does your client bring an appeal on a conditional basis?
Because we're not in the business of wasting judicial resources. If the rules are found to be unconstitutional, even for the two reasons, you know, Justice Taron, that we say they are unconstitutional for more, but let's confine it to the two. So if they are unconstitutional just for those two reasons, then Parliament, let me give you an example. For example, there's a place where the judges are saying, look, it would be preferable to give Audi before the in-order finding, but we're not going to make a finding about that. Then hopefully a reasonable Parliament will take heed of all those things and not only confine its recrafting of the rules to those two grounds. Now, if that happens, and the public protector will probably make representations as well, not just the public protector, all the other heads of the institutions. So it is because it's a pragmatic thing, Justice Taron, which says that once the rules have been found to be unconstitutional on two grounds, what's the point of then saying, let's waste this time of the SCA, the High Court, and this court by declaring them unconstitutional for another ground as well? Because if they are unconstitutional, they are unconstitutional. And so we can now be, our own pragmatism is used against us, basically to say, no, what you should have done is to appeal, to say, even if the two grounds are dismissed, the rules must nevertheless, all these courts must waste their time. An application for leave to appeal in Cape Town, and then an appeal in Bloemfontein, and another appeal here. For what? Simply to reaffirm the fact that...
On what basis does your client claim that the rules impermissibly permit the Chief Justice and the Speaker to appoint a judge? Because all that has happened is a judge is appointed to serve non-judicially on the panel.
Yes, very good. But appointed by whom? The point is that the judge is appointed by the Speaker to do whatever. It might be just to do nothing. But the point is, we must accept that the judge, for whatever reason, in this formulation, Justice Mhlantla went through this. If you look at 129V, there can be no doubt in anybody's mind who is the appointing authority, let's call it that. And the appointing authority is the Speaker. Now, the head of the legislature appoints a judge in consultation with the head of the judiciary. If there's nothing wrong with that picture, where the Speaker of Parliament derives powers from God knows where to appoint a judge or designate a judge or assign, it doesn't, you can put it at its lowest, to assign a judge to do something, then that's the end of the democracy. Because it means then the Speaker, without satisfying the fair short test, without satisfying the pharmaceutical, what else can she not do? Why can't she just wake up and appoint the principal of the University of Limpopo? Because unless if she has a power that we know, for her to appoint a judge or assign a judge or designate a judge to do anything. However, that thing might be the slightest thing. Might be saying, I'm designating this judge just to go and pick up a glass of water. But where does she get that power?
Mr.
Nowhere.
Mpofu, yeah, Mr. Mpofu, I've turned my video off because I have load shedding in my battery. My battery is very low.
Yes, I can still hear you, Justice Taron.
Okay, thank you. Please, can you clarify, is the public protector contending that the rules are procedurally irrational because they only provide for a hearing at an advanced stage of the process?
Yes, that's one of the grounds. We say they are irrational for various grounds, which we spoke about this morning. They are irrational for various grounds, but on procedural irrationality per se, a la Albut and all those cases? Yes, the answer is that this is where we say that the refusal or the failure, maybe let me put it broadly, and I'll just pick up two things at random. We say, or three, the failure to grant a hearing at the stage of the in-order decision, the refusal of legal representation, and the refusal.
Let's just deal with the failure to grant a hearing at an early stage.
In order stage.
Yes. Is the argument then that you're basically asking for a hearing before a hearing? And I thought this court's or the SCA's judgment in Langer versus Slope would not assist you in there.
No.
That there's no right to a hearing before a hearing.
No, the judgment must look at is NERSA, which says that in a multi-staged process, you are entitled to your constitutional right in all the stages. But let's assume that was correct. If that was correct, then why is it that the public protector has a right to make representation at the panel stage, and then again has the right to admittedly truncated legal representation at the ad hoc stage? Because it would, if that was the answer, it would say, well, you can't have two rights to legal representation. No, it doesn't work like that. If there are stages, hundreds of stages, all of which result in an adverse decision to your rights, then in all 100 of those stages, you must be granted your constitutional rights. Unless the only way that can be escaped is if one of those stages, as it is argued here wrongly, is purely about form. The court ACO made a fundamental mistake about that, because they said these rules only deal with form. Well, that's a gross misdirection, because these rules make it clear that the role of the speaker is not merely to tick boxes about the complaint. It is to look as to whether the complaint is constitutional, whether there's prima facie evidence, and actually for her to receive the evidence and look at it. That's not a tick boxing exercise. And once you've made, that's why we use the example of a prosecutor. Once she makes that decision, substantive decision, not form, not to say, oh, did you do this thing in triplicate? No, it is to make a substantive.
So are you saying then that the public protector has a right to a hearing before a hearing?
Yes, I am. I'm saying if that stage is in itself circumscribed or self-contained, such as the panel stage, because that stage has its own four corners. That's why the public protector is granted the right to a hearing at that stage, a separate right to a hearing than the other one, because that is the law. Because according to NERSA, if those two, let's look at those two stages. If each, you can't say I'm denying you the right to a hearing at the panel stage because you will get it in front of the committee. No, it doesn't work like that. The test is simple: whether at the panel stage your rights are adversely affected, yes or no. If the answer is no, then you're not entitled to Audi. But if the answer is yes, then you are entitled to Audi. That logic is the same as for the speaker at the so-called in-order stage.
Now, Mr. Mpofu, yes, I get your answer there.
Thank you very much.
In the cross appeal, the public protector also contends that she's entitled to reasons upon demand at the preliminary stage of the investigation. Is that right?
Yes.
Would that not frustrate most investigations?
Well, I don't know about most investigations, but I'm here about the rights of the public protector. The point here is that the public protector, let's assume for now, Justice Theron, that you agree with me. I know it might be an extravagant assumption, but let's assume that you agree with me that the in order stage is in its own right, takes away rights or gives rights. Yeah. Now, if that is the case, then it's inherent. The cases are replete with this, that the right to reasons is inherent in the right to a hearing, because the right to a hearing would be nonsensical and hollow if the decision maker is not going to give you reasons. Then what's the point of a hearing? So what we're saying is that if the speaker makes a substantive decision, let's say, and I may be right or wrong about that, but if she does, then two things arise. One is about Audi, the other one is about rationality. The first one is that then she must give a right to a hearing. But the more serious problem is this, and it applies to this case specifically. Remember that what the speaker says, she says, I didn't have to give you reasons in the December 2019 motion. Then came the February 2020 motion. And I also didn't give you reasons, and I gave you, but remember that I gave them to you in the answering affidavit. I mean, that is completely ridiculous, because what it means is that the giving or non-giving of reasons is at the whim of the speaker. One day, if she feels like giving you reasons, she'll give it to you, as she did in February 2020. But on another day, if she doesn't feel like giving you reasons, as in December 2019, she won't give you reasons. That's what the courts have said would be the whimsical. You cannot leave, that's arbitrariness now, which is a more serious problem than Audi. You can't leave decisions of that nature to the whimsical choices of the decision maker. No explanation. She just, I gave it. So she must decide whimsically whether to give the reasons and when to give them. Then she gives them in the answering affidavit. You must also be happy.
I have your answer on that one. Also, in the cross appeal, the public protector raises the question of retrospectivity.
Right.
Yeah. Now, you will agree that procedural rules have retrospective effect. If the rules do not have retrospective effect, it would mean that Parliament would not be able to perform its function of holding the public protector to account. Would that not in itself be reason to read the rules as having retrospective effect? Yes.
Yes, no, thank you. Thank you so much, Justice Theron. Thank you, because that's a point I wanted to make, which I didn't have time to make. No. Firstly, the retrospectivity, well, I've already argued, I won't go over that these rules are a hybrid at best. So they are both procedural and substantive. So that exception wouldn't apply, even if it was a real exception. Losa says it's a phantom exception, but let's assume it was a real exception. It wouldn't apply here because the rules are, on everybody's version, both procedural and substantive. That's the first point. The second point, which is more important, and I think it was Mr. Breitenbach who put the finger on the nail, is that this exercise is misunderstood. This exercise about retrospectivity is about to search for one thing and one thing only, the intention of the drafter. Let's call it that. Now, that intention of the drafter cannot be taken from the air. Well, firstly, in this case, the drafter is here, and she has not said what you're saying, Justice Theron. She doesn't say, on neither does Parliament say, look, we left out this thing about retrospectivity because it would be obvious. No. They left it out, and that's why your only job is to find out why did they leave it out. Did they leave it out consciously? Or did they intend to put it and forgot to put it, which would also be bad? Or did they intend to put it and nevertheless relied on its obvious nature? So there are three scenarios. Here, you cannot say Parliament intended, because Parliament knew what you and I know, Justice Taron, that the motive of the DA in putting these rules in the first place was to punish the public protector for transgressions which were done in 2017 and 2018 and 2019. They knew that. So Parliament would have then said, we are, as Parliament, put what every case on retrospectivity says. We are putting a clause that says these rules shall apply with retrospective effect, because they were mindful of that. But the failure of Parliament to put that is presumed. That's why it's called a presumption against retrospectivity. The failure for Parliament to do that is presumed to mean that they did not want it to be retrospective. That presumption is not irrebuttable. It's rebuttable by either construction by a court or the person, the drafter, saying, no, it's because, we thought it's so obvious that the rules should operate prospectively. One would say a rational drafter would still put it, even if it was so obvious. They would still put it so that we wouldn't be arguing it now. But here, the drafters are not even saying today. You are being told by lawyers that they must have intended for it to be retrospective, because they have not said, they have affidavits in front of you. They have never, the speaker has never said that we intended, we subjectively as Parliament, for whom I speak in terms of the Powers and Privileges Act. I can tell you now that we intended, we might have omitted because we were busy, but we intended for the rules to be retrospective. They don't say that. So on what basis can this court rebut the presumption? Just because Mr. Breitenbach says that surely they must have wanted to be retrospective. No, it doesn't work like that.
My last question on the cross appeal, Mr. Mpofu. Does the public protector contend that the rules impermissibly expand the definitions of misconduct or incapacity?
Yes.
Now, didn't this court in EFF2 hold that it was up to Parliament to fill in the details for the grounds of removal?
Yes, I've addressed that. Actually, the wording that was used by the court was to spell out the details. And I've said that that one is a simple question of interpretation. It is whether this court will find that, as I say, adding a new offense of temporary incapacity or a temporary condition amounts to spelling out or the detail, or actually amounts to adding or alteration and expanding, which is impermissible. What is impermissible is not the spelling out. That is obvious, and it's allowed by the court, the case, the court in the EFF impeachment case. But that just begs the question: is what is done here? If you go to the definition on misconduct, and it introduces the issue of gross negligence for the first time on the 3rd of December 2019. Is that what you call it, spelling out, or is that, as Mr. Breitenbach calls it, narrowing the ground? Let's say it's a narrowing, but Parliament, or rather, yes, Parliament is not allowed to narrow anything in the Constitution. If the Constitution wanted to narrow it, then they must amend the Constitution. So the narrowing is unconstitutional. Then let's take the other one, which is the expansion. as far as incapacity is concerned, this time they're not narrowing the definition, they expanded it by adding the temporary incapacity. That is not allowed either. So whether you are narrowing or expanding, you may not alter something that the founders of the Constitution put there without having a 2/3 majority of Parliament. An amendment of the Constitution, if they wanted to amend Section 194 to include temporary incapacity or gross negligence or whatever, then they must do the right thing, which is spelled out in the Constitution. Make a notice, put it to the test, let it be voted upon, and so on. And then it will be properly amended. You can't do it through the back door of using the rules. It would be like using the Uniform Rules of Court. Justice Rogers made that example. If you use the Uniform Rules of Court to amend the Superior Courts Act, for example. So the Superior Courts Act says something must be done within 20 days. And then the rules, the Uniform Rules of Court come and say, no, it must be done in 2 months. You can't do that because or vice versa, or the Constitution, to make it worse, says it must be done in 10 days. And then the legislature or some rule-making body, remember Parliament here is not sitting as the legislature per se. It is sitting as a rule-making body like any other rule-making body. So some rule-making body altering a parliament, not even a legislative provision, a constitutional one, is anathema to the idea of the rule of law. So you can.
Thank you, Mr. Mpofu. You have answered my questions. And thank you for the indulgence, Justice Madlanga. Justice Madlanga, I would like to point out that Justice Madondo has reconnected, and I'm not sure we might, if you want to ask him if he has any questions before Justice Mpofu leaves us. I don't see Justice Madondo, but he has been admitted into the hearing room.
Thank you, my sister, Justice Theron. Mr. Naidu. Mr. Naidu. Justice Madondo, if you are with us, do you have any questions for Mr. Mpofu? Thank you very much, Mr. Mpofu. Mr. Breidenbach.
Thank you, Justice Madlanga. I'm indebted to the court. Thank you.
Thank you, Justice Madlanga. I'd like to deal first with the issue of urgency and direct appeal. It seems to us that the issue of urgency became academic on the 15th of September, when after the filing of the founding and the answering papers, the acting Chief Justice directed that the hearing of this matter be held today. In any event, both the Speaker and the Democratic Alliance motivated an urgent direct appeal in their founding papers in this court. Justice Theron has referred to part of the papers. In the Speaker's papers, Volume 8, pages 763 to 767, paragraphs 89 to 98, and in the DA's founding affidavit, I say this hesitantly, my learned friend may have more references, same volume, 791, paragraph 9, 815 to 817, 39 to 45, and 818 to 819, 53 to 57. My learned friend appeared to labour under a misapprehension that the Speaker and the DA had the right to file a replying affidavit. Rule 19 does not afford applicants under that rule such a right, and it is an indulgence which is very sparingly granted. In this case, there was no need for it. The motivation was given in the founding papers, and as regards our written submissions for the Speaker, at pages 13 to 15, paragraphs 30 to 35, we further motivated a direct appeal to this court, including in paragraph 34 on the ground of urgency. In that regard, may I elaborate briefly as follows. The proceedings in the Assembly in relation to the motion for the removal of the incumbent public protector are in our submission important and must be considered or concluded one way or the other as soon as practically possible, and the reasons for that are with respect self-evident. Firstly, Advocate Mkhwebane is the incumbent of a very important public office. Secondly, the charges against her are serious. Many of them are based on severe judicial rebukes of her conduct of important investigations and her conduct in the ensuing litigation about them. Thirdly, the determination of the issues raised in this appeal will have a material impact on the Assembly's proceedings, which have been suspended pending the outcome of this matter. And lastly, those proceedings have proceeded to the stage where a Section 194 committee has been appointed, but as I say, have been suspended. If, as my learned friend would have it, the matter were to proceed to the SCA, as I submitted in my main address, it's highly likely that the losing party would launch a further application to this court for leave to appeal to it. The result of that would be a continuation of the current uncertainty and very likely a continuation of the current delay because of the position which Parliament has adopted, namely deference to these proceedings to suspend the Section 194 proceedings pending the final determination of the challenge to the rules. The next issue I wish to deal with, a couple of issues, concern the proviso to Rule 129 AD sub 3. This morning I was asked about Section 34 of the Constitution and whether it's applicable to Section 194 impeachment proceedings. And my learned friend this afternoon for Advocate Mkhwebane submitted that it was applicable. It occurred to me that my client dealt with this issue in her answering affidavit. It's at volume 2, page 182, 166, where she gave two reasons which we respectfully advance for the non-applicability. The first is an impeachment motion does not raise a legal dispute. That is one which can be resolved solely by the application of law. Secondly, the ultimate decision-making body, which is the Plenary National Assembly, is not a court or an independent and impartial tribunal and forum. Although the impeachment process is governed by Section 194 in the new rules, and the thing is that the outcome or the resolution of the process is determined by an exercise of political judgment made by a body comprising representatives of the political parties elected by the people in a general election. And the nature of that political judgment is dealt with in the preceding paragraph 165 in the Speaker's affidavit. And so with respect, it is our submission that the only potential source of the right to unrestricted legal representation before a Section 194 committee is the principle of rationality, in the two senses raised with me during my argument today. The first is procedural rationality. It may require unrestricted legal representation. The second is avoiding irrational differentiation between the position of the President may require it. I've made my submissions in that regard and don't intend repeating them. As regards my colleague's reliance on Section 177 of the Constitution, that's the impeachment provision in relation to judicial officers. Although he is right that Section 28 sub 2 of the Judicial Service Commission Act does provide for a judge to be legally represented in a tribunal investigating a complaint of judicial misconduct. That concerns a procedure outside Parliament regulated by an Act of Parliament. Here we are concerned with a procedure inside Parliament regulated by the rules made by a House of Parliament. And the only comparator to that is, of course, the rules regulating impeachment proceedings under Section 89 of the Constitution. The third point that I wish to make is a little off my division of labour with my learned friend, Mr. Budlander, but I do think in the circumstances and having heard my learned friend's submissions, I need to say a word about the retrospectivity of an order of constitutional invalidity in relation to Rule 129V, the one providing for the appointment of a judicial officer, a judge, to the independent panel. The first thing I wish to say, and I say this with some trepidation, but I have checked with my team. My juniors and I do not recall my learned friend abandoning prayer 4 of his notice of motion in the High Court. The second thing is, in the High Court, certainly on the pleadings and on the heads of argument, there was no question of retrospectivity. Advocate Mkhwebane had sought the polar opposite in her notice of motion, a 6-month suspension of any order of invalidity. My client agreed with that, both on the affidavits and through us in argument. As regards our argument, I refer the court to our heads, page 27, paragraph 60, footnote 74, the second sentence. Turning to...
Sorry, Mr. Breitenbach, can I just ask on that question? If a court suspends a declaration of invalidity, say for 6 months,
yes,
and the lawmaker doesn't take remedial action within that time,
yes,
does the order of declaration then come into effect on the expiry of the 6 months without any retrospective effect? Or could
yes.
the order, could a court, are you aware of any authority where a court in some way combines a suspension of a declaration of invalidity with some sort of order of retrospectivity, or are they mutually?
21B, saying that if Parliament or whoever it is given the job of attending to the defect within the period, doesn't remediate it by the end of the period, then the order of invalidity will operate ex tunc from either the inception of the measure, if it postdated the Constitution, or the commencement of the Constitution, if the measure predated the Constitution.
And
but
the remedial action of the lawmaker under that sort of regime doesn't need to pass retrospective legislation. It can pass an amendment with effect from the current date.
With respect, that's exactly correct. So the effect of an order of suspension of invalidity, as I understand our jurisprudence, is that if the lawmaker does what is required of it within the period of suspension, then the order of invalidity will never come into force. There will be a declaration under section 172(1)A, but it will never be effective because it was decided that justice and equity required that there not be any immediate, let alone retroactive consequences, and that instead those responsible for the measure be given the opportunity to rectify the defect. Sometimes, as your lordship will be aware, for instance, from the Auction Alliance case, which as I recall may have been an appeal from a judgment which you gave in the High Court, or in a similar matter, the court adjusts the position in the meantime. That is fairly common. The Prince case is perhaps the most popularly well-known example of that, where the court made an interim arrangement in relation to the use and possession and use of cannabis for personal use, cultivation, etc., in the period of suspension. There is a further point, though, that I wish to raise in this regard,
the 10 minutes is up, Mr. Breitenbach. How much more time do you want?
Very little time. I need to make this point, and I then just want to talk about the order. Another 2 minutes, if I may.
2 minutes over. Thank you.
Thank you. So the first thing is that this court, as Justice Theron pointed out, is seized of this matter if it grants the application for leave to appeal. And if it is against us on the question of the constitutional validity of 129V, then the court is empowered and obliged to consider whether or not to grant a just and equitable order. The court does have the evidence, the relevant evidence before it in that regard. The evidence, in other words, from our side supporting an order of non-retrospectivity made in terms of 172(1)(b)(1). And I refer to the Speaker's founding affidavit, volume 8, 760 to 763, paragraphs 81 to 88, and the DA's founding affidavit in the same volume, 811 to 815, paragraph 37, which is a very lengthy paragraph with many subparagraphs. Finally, then, the relief. The Speaker does not seek a costs order in the event of her succeeding in this matter. You will have seen from the notice of motion there's no prayer for costs. We submit the same should apply should the speaker be unsuccessful, wholly or in part. The main reason is both the Parliament and the Public Protector are funded from the public purse. So the speaker accordingly seeks relief in accordance with her notice of motion at pages 717 to 719, paragraphs 1 to 3. And it is with respect, we submit helpfully restated in our written submissions in a slightly different form, less cryptic, pages 48 to 50, paragraphs 130 to 134. Those are our submissions.
Thank you very much, Mr. Breitenbach. Colleagues, I just got a text that our colleague, Justice Madondo, who lost connectivity, has questions for Mr. Mpofu. I'm thinking perhaps let us interpose that now, so that if Mr. Breitenbach has any further response to that, he may do that very briefly, and then Mr. Badlander may respond to everything, including responses given in answer to Justice Madondo's questions. Is that in order, colleagues, or what do colleagues suggest? All right. Yes, Justice Madondo.
Thank you, Justice Madlanga. Mr. Mpofu.
Yes, Justice Madondo.
Does the National Assembly have, or let me put it in this way, is the Legislative Assembly entitled to make rules and run its own processes?
Yes, in terms of section 57(1)(b) of the Constitution, yes, Justice Madondo.
So is there anything wrong with the putting in place of the mechanism which is designed for the removal of the head of Chapter 9 institutions?
Yes, there is something wrong if the rules are, it just begs the question, if the rules are unlawful or unconstitutional, then there's something wrong. It's like there was an example that was given, Justice Madondo, by Justice Rogers about the uniform rules of court. And the question, a complementary question would be, is the rules committee entitled to make rules of court? The answer is yes. And therefore, is there something wrong if they make a rule, let's call it Rule 25? The answer is it depends. If that Rule 25 is constitutional, then we're fine. But if that Rule 25, as I was saying, just to emphasize the point, provides for a sexist or racist provision, and I'm just doing that for effect, then there's yes. Then the answer is yes, there's something wrong. So the question just begs the question of constitutionality. The Parliament, if you read section 57(1)(b) of the Constitution, which is the empowering provision, you must assume that there's a word there missing that is called lawful or constitutional. In other words, it says the National Assembly may make and put lawful and constitutional rules and orders concerning its business with due regard to this. But once those rules are unconstitutional and unlawful, then they cannot be made under 57(1)(b). In other words, they don't have a right to make any rules that they may wake up and make.
Okay. So does this procedure target a particular individual, or it applies to all heads of Chapter 9 institutions?
Okay, at face value, that's a very important question. Thank you, Justice Madondo. That is what we call the sobukwe clause nature of this. Because although at face value it pretends to be about all Chapter 9 institutions, in fact, we made these submissions in the High Court. Right up to December, even the DA, which was sponsoring these rules, was calling it the rules for the removal of the public protector, until somebody pointed out that no, and then suddenly the language changed. And the reason, one of the reasons that it is betrayed, that betrays the fact that these rules were actually targeted at not just the public protector, but Advocate Mkhwebane, which is even worse, is the excuse that they give, Justice Madondo, to the question of legal representation. You remember one of their answers is to say, no, but she's legally trained. So, which shows that the rules were made because the only Chapter 9 institution head that is legally trained is her. So it shows you that the rules were always targeted at her. And then only when we point out, as the Justices Mhlanhla and I think Justice Chikwi pointed out at the beginning of the case this morning, that you can't use that, the fact that she has an LLB, because these rules are targeted at everybody, including the AG, who's probably an accountant. Then they say, oh no, well, I don't even know what they say. They don't say anything intelligible. But the mere fact that they raised that defense shows that in reality, these rules were targeted not just at the public protector, but at Advocate Mkhwebane specifically.
Okay, thank you, Mr. Mpofu, and thank you, Justice Madlanga.
Thank you, my colleague. Thank you, Mr. Mpofu. Mr. Bach, do you have any questions arising from this further response?
I have one very brief submission, and it relates to the point just made by my learned friend. It is not correct that the Speaker's answering affidavit reveals a fixation on the public protector. The relevant paragraph is in volume 2, at page 187, paragraph 181. After giving in paragraph 179 the main reason, personal accountability, and referring in paragraph 180 to earlier allegations about this not being administrative action, what the Speaker says is the following, and I emphasize the first sentence. Finally, in this regard, it also bears mentioning that the public protector, like the Auditor General and the commissioners of the Chapter 9 commissions, is no hapless accused, and then goes on to deal with the requirements for the appointment of the public protector. I have expressly said we do not rely on that as a reason because we accept that the legal experience requirements apply only to the public protector. But insofar as it's suggested that these rules were tailored specifically to deal with the public protector, that's not right. The facts are clear. The public protector, when the issue of impeachment was raised shortly after the commencement of the 6th Parliament in May 2019, wrote to the Speaker saying, my impeachment cannot be process unless and until there are rules. That question was referred to the Justice Committee in the Assembly, which agreed with her and suggested that the Speaker refer the matter to the Rules Committee, which she did. The rules were drafted as rules applicable on their face and in substance to all Chapter 9 institutions. And as I've just indicated, the passage on which my learned friend relies does not sustain the point just made.
Thank you, Mr. Breitenbach. Mr. Badlander?
Thank you very much, Justice Madlanga, members of the court. I will deal with 4 issues in this brief reply. I will say one word about accountability. Then I will deal with the judge issue. Thirdly, I will deal with the question of remedy. And finally, I will deal with the question of retrospectivity. On the question of accountability, I began, Justice Madlanga, today by saying that from my client's perspective, this is fundamentally a case about accountability. It is a case which, if not correctly decided, and if the High Court judgment is upheld, will allow the public protector to avoid accountability. and I explained throughout why a number of her arguments appear calculated to avoid any removal processes taking place at all. It's not an attempt to try and get herself acquitted, it's an attempt to prevent even a process taking place. None of that has been answered, and all of that is fundamentally relevant to the question of direct appeal and urgency. And if I didn't say the word urgency, it's because I thought, with respect, it was so obvious that it flowed from my submissions on the need for accountability and the need for an expedited hearing. So with great respect, the suggestion that somehow this should be kicked via Bloemfontein towards the end of the public protector's term or somehow dealt with in the ordinary course is without any merit. Could I then deal with the second issue, which is the question of the judge? I've listened carefully to my learned friend's address. There has really been no answer given to the arguments we have advanced on how this case is not analogous to Heath or the NSPCA, and on how applying those tests, there is no basis for contending that it is impermissible to have a judge appointed. The only argument that really needs to be dealt with, in addition to what I've already said, is the contention that if you have a judge who is nominated by the ACDP, for example, that judge is regarded as the ACDP judge and will lose independence and credibility. But with great respect, that submission cannot hold any water. The proposition seems to be this: where the judge is nominated by one political party, is appointed not by that party, but by the Speaker, acting in concurrence with the Chief Justice, who is not limited to administrative considerations, but can take into account whatever considerations he deems fit, where that judge is appointed for a non-binding evaluation, not for a determination of whether the public protector will be removed, where that judge is appointed for a task that is well suited to judges to examine whether prima facie case exists, and where that judge must, with other panel members, give reasons in a report. In that context, the proposition advanced is that that judge will forevermore be known as the ACDP judge. Well, with great respect, there's no basis for that. When you apply the test that is set out in Van Rooyen, that the test of independence is the thoughtful, reasonable, well-informed observer. No thoughtful, reasonable, or well-informed observer would regard Justice Nkabinde as being the ACDP judge or the Freedom Front judge just because she happened to have been nominated by a given party. And that really is the only new point that my learned friend has made, and it is a point without any merit whatsoever, with great respect. That then takes me to the question of remedy, on which my learned friend spent so long. And it is necessary, with respect, to remind the court, and it's surprising that one should have to do so, but to remind the court what the effect is of a suspension order under 172. Could I direct the court's attention to the judgment of this court in Johannesburg Metropolitan Municipality versus Gauteng Development Tribunal, 2010, volume 6 of the South African Law Reports, page 182. It's a decision of this court at paragraph 73. There, this court said as follows: in circumstances where serious disruptions or dislocations in state administration would ensue, if the order of invalidity takes immediate effect, Section 172 explicitly authorizes a court to suspend the order for a period determined by that court. And then there's a footnote, and the footnote is ironically to the Heath judgment at the very paragraphs Justice Taron took me to, 49 to 50. But so the court, just to return, the court says that's what is authorized, is a suspension for a period. The effect of the suspension is that the invalid law continues to operate with full force and effect. Now, this court knows all this. It is truly Constitutional Law 101. So why am I emphasizing the point? Because the point I wish to make is that the distinction that my learned friend seeks to draw between an order of suspension on the one hand and an order of non-retrospectivity on the other is entirely artificial. When one suspends an order of invalidity, one doesn't only say it doesn't have prospective effect, one says it doesn't even have immediate effect. One leaves it in place for the next 6 months or year. The invalid law, in the words of this court, the invalid law continues to operate with full force and effect. That would have been the effect had paragraph 4 of the Public Protector's Notice of Motion been granted. The invalid rules, if they were found to be invalid, would continue to operate with full force and effect. So you don't even have to worry, if that were the order, about prospective or retrospective. And it's in that context, with respect, that you must read the Public Protector's papers. And it's in that context that you must assess the contention that the question of prospective or retrospectivity was never raised. Now, I will make one concession. My learned friend is quite correct that I had overlooked paragraph 142 of the supplementary affidavit, which appears at page 464. But with great respect, that makes his case worse, not better. Because when you go and read paragraph 142, it says, "It is my respectful submission that the court should grant an order as prayed in the notice of motion, including an order suspending the declaration of invalidity and remit the impugned rules to the National Assembly for redrafting, as well as redrafting of the rules governing the 194 inquiry." Well, what does that mean? I've just said what it means. In the language of this court's decision, it means the invalid rules will continue to operate with full force and effect. And so then when he says, and then in the next paragraph, which wasn't read to you, the proposed suspension should be for a period of 6 to 12 months or any period suitable to allow the National Assembly to perform this task within a reasonable time. So the clear implication of paragraph 4, coupled with the paragraphs of the notice of motion, coupled with paragraphs 142 and 143, is that there's no need to worry about retrospectivity or prospectivity because the order will be suspended for 6 to 12 months or any period suitable. Now, perhaps the Public Protector misunderstood this court's jurisprudence. Perhaps my learned friend did, but that is what was on the papers. So to suggest that somehow there had to be a separate pleading on that is without any merit. And I agree with my learned friend, Mr. Breitenbach, that I have no recollection at all of prayer 4 being abandoned. The last point on the remedy, Justice Madlanka, is even if I'm wrong on all of that, our learned friend has offered no answer to my reference to paragraph 211 of EFF 2, to my reference to paragraph 53 of Lange versus the Premier from Friday. Even if it were true that my client and the speaker had somehow omitted to deal with retrospectivity, that could never absolve this court of its duty to grant a just and equitable remedy. And it is true that there are cases in the past, like Mystery, which say that you must put up the facts relevant to suspension. But the facts are there. The facts are common cause, Justice Madlanga, because the common cause facts are, there was a panel appointed. The panel included Justice Nkabinde, a retired judge. The panel delivered its report. The report was relied on in going forward and in appointing the committee. And that is the state of play. Those facts demonstrate the disruption. Those facts are common cause. And it's not clear what on earth else one would need to have put up in order to motivate a non-retrospective order. So if the court is against us on the judge issue, the order plainly, at the very least, should be prospective only to avoid this difficulty. Lastly, Justice Madlanga, on the question of retrospective interpretation, our learned friend doesn't take issue with the proposition in my address that the presumption, our learned friend says two things. He accepts that the question of retrospectivity is an interpretive question. He accepts that expressly, as he does in his heads, and that's right with respect. He also doesn't take issue with my proposition that the presumption of retrospectivity against retrospectivity only kicks in, not when there's a substantive effect, but a substantive adverse effect. And that's what the language in Haffajee says, that's what the language in Nkabinde says, and it's the language in Feldman. He doesn't take issue with that. But then you ask yourself with respect, where did he point to the substantive adverse effect? Where did he point to the vested right that was taken away? And it was that drove him into the reference to nulla pena sine lege, the idea that you cannot suffer a penalty where there is no law. But with respect, there is a law. The law is section 194 of the Constitution. It says, and it has said since 1997, it says that a public protector can be removed on grounds of misconduct, incapacity, or incompetence. The rules don't produce that. The rules merely operationalize that. So the idea of nulla pena sine lege is without any merit whatsoever. And I repeat, the only substantive adverse effect is if the argument is truly that the public protector and the IEC and the Auditor General are all immune from any removal whether they commit a crime, whether they murder someone, whether they engage in corrupt acts, they are immune absent those rules. And even once the rules are enacted, they can't fix them. So there is nothing in that point with respect, which takes us to the last element of retrospectivity. And that is the debate about expanding or narrowing the grounds.
And your 10 minutes, is up. How much more time do you want, Mr. Butler?
I think it's 90 seconds, if I may, Justice Madlanga. Yeah. On the question of the grounds, our learned friend says, well, there's the expanding of the grounds, but the only ground he can point to expanding, and we don't accept any expansion, the only ground he can point to expansion is incapacity, which is utterly irrelevant to this case. And I don't accept that there's an expansion, because incapacity is still incapacity. And as I explained, and which was not answered, it's still just a debate about whether it was a temporary cause of the incapacity or a permanent cause. The difference between someone who is in a car accident and will recover in 2 years' time, that's temporary, and someone who is in a car accident and in a vegetative state and will never recover, that might be permanent. So that point is A, irrelevant to these proceedings, and B, utterly unfounded. Which then leaves us the last point. And the last point is the ground of misconduct. And so he accepts with respect that misconduct does not, the definition of misconduct in the rules does not involve expanding the grounds. My learned friend accepts that. So now he tries something different. He says, well, Parliament can't narrow it either. But with respect, Parliament hasn't narrowed it in that sense. Parliament has defined it in the sense that was required by EFF2. Paragraphs 176 to 178, where this court said Parliament must define it. Well, when you define it, inevitably what you do is you tighten it. And that's what's happened here. So whichever way you look at it, there is no basis for a complaint about, there's no basis for an interpretive argument on retrospectivity, because retrospectivity, the presumption doesn't kick in, but even if the presumption did kick in, it is overcome by the context. And that's the last point I would make. Our learned friend seems to suggest that I have to point to a passage in the affidavit of the speaker who says we intended it to be retrospective. With great respect, that is impermissible, just as it would be impermissible for one member of Parliament or the speaker to explain the intention behind a particular act. An interpretation of an act is an objective inquiry derived from looking at the relevant context, as we all know. And the context in this case is there was a provision to remove the public protector and other Chapter 9 institutions. This court said there had to be rules. The rules were made in a context where there was an objection which says you can't even think about removing me because there are no rules, and that would apply to the rest of the Chapter 9 institutions. Now, to interpret it in that context as saying these rules have no retrospective intent and that they were never meant to deal with anything in the past, with respect, would be absurd. And there's simply no basis for that. And one does not need an affidavit for that purpose. And indeed, it would probably be impermissible to rely on an affidavit for that purpose, because interpretation of rules or a statute is an objective inquiry. So we persist in saying with respect that the DA's appeal should be upheld and that the public protector should be directed to pay the costs, including the costs of 2 counsel, in respect of the DA. I've heard what my learned friend for the speaker says. He and the public protector can have that debate. The DA is in a different position, and we do seek the costs. Thank you, Justice Madlanga, members of the court.
Thank you, Mr. Badlenda. Mr. Mpofu, some ground rules. Yes, we agreed in chambers that because you have a counter appeal, you'll have a right to reply. But just to make sure that there won't be a reply to that part of the reply by your colleagues, which has nothing to do with the counter, your counter. When you raise an issue, please tell us specifically to what part of the counter application it relates, so we can just be sure that you do not stray outside of those parameters. Thank you very much, Mr. Mpofu.
Thank you. Thank you, Justice Madlanga.
Yes.
Thank you, Justice Madlanga. And I'd like to know at some stage whether that regime extends to that part of the argument which should have been raised in chief, which has now been raised in reply. But we'll come to that just now, which is about urgency and all sorts of things. But because it's unfair, let me just put that on the record. It's very unfair for me to be expected to, we raise an issue as a point in limine in an affidavit. We come here, it's not raised in chief, and then it's raised in reply to my raising it. And then I can't say anything about it, but that's fine. The first point, Justice Madlanga, that we want to make is this. In this reply, I will emphasize firstly a point that I made in chief, namely that I'm explaining why the reply will look like it emphasizes the question of remedy more than other things. That's because the question of remedy, as I said earlier, is directly intertwined with the fate, if you like, of the cross appeal, which I'm replying to now. In other words, if the cross appeal is successful, that has a direct bearing. It would have had a direct bearing in the court and even in this court as to whether this or that remedial action should be granted. That should be obvious. So this is not a simple case where there's an appeal and then it succeeds and then you give remedial action. It would be a case where there's an appeal and it succeeds or fails, but there's also another appeal by us about the same rules, which, if it is successful, will in itself span a duty to give remedial action in its own right. So if the court can keep that at the back of its mind in everything that I'm going to say. Now, the reason why that is important is because the exercise of discretionary power, let's assume for a minute, put aside issues of, I'm glad it has now been considered that it was considered at least by Mr. Breitenbach, but resuscitated by Mr. Badlander, because he's insisting incorrectly, despite what I've said, that we were invoking section 172 1B1. Well, nothing could be further from the truth, because in I think it's page 505. Where, oh yeah, it is. In volume 6. The speaker says, my second assumption regarding the amended notice of motion. Remember at page 464, we had made it clear that we rely on 172 1B Roman 2. We even underlined it. So this is the response. My second assumption regarding the amended notice of motion is that the order of suspension for 6 months of the declaration of invalidity sought in paragraph 4, if granted, will have the usual legal effects of unconditional order of suspension made in terms of section 172 1B Roman 1. So that's where the fallacy came, because they made a wrong assumption that that argument was being made in terms of Roman figure 1, which was wrong. This is our response in the reply at paragraph at page 602, volume 7. And it can be clearer than this. It says, regarding the structural relief, that's at paragraph 11.3, I wish to clarify the present situation must not be confused with the striking down of legislation for want of constitutionality. In other words, in terms of section 172 2B, I think. Although there are indeed similarities, we say, but here's the punchline. In the present case of the rules, what must happen in the interim must be left to the discretion of the court after the hearing of arguments. This, in turn, will inter alia be determined by many considerations, including the fate of Part A, the Part A appeal process, which was still pending, and common sense and/or any fresh interim applications which may be brought by any interested party in view of any material changes of fact That is the explanation I gave, that it was our attempt to say, although Part A may not have been granted, we can revive Part A and ask for an interim order under Section 172(2)(b) if this situation changes, which we're entitled to do, because that's the definition of an interim order, is that you can go back to the same court and ask for Part A. We abandoned that effort for the reasons that I've mentioned. And if Mr. Badlander or Mr. Breitenbach Juniors do not remember us abandoning that, that's just a double negative. The question is whether do they remember us pursuing that that point? No. Why? Because and as I even said, let's assume we did pursue it and failed. Then they can't appeal for us. That's disingenuous. That's just complete disingenuous if we had actually raised it. But here's the key, Justice Madanga. It is because we said it must be left to the discretion of the court, as these things usually are. In other words, the High Court, having exercised its discretion, right, decided in its wisdom not to grant an order of prospectivity. And therefore, how can this court reverse that exercise of that discretion, which we asked for, without saying that it was exercised injudiciously? You know, we know the usual rules. This is an appeal court. This court cannot, sitting as a court of appeal, even if it was us who were raising this point, because we're told that it was raised by us, which is really just absurd. But even if it was raised by us and then it failed in the discretion of the High Court, how could this court simply undo that discretion without saying that the High Court had exercised it wrongly? That's just, it's a cul-de-sac. They can't argue what they're arguing. Then the cross appeal on retrospectivity is now opposed on a new basis, which is that the rules, this is Mr. Badlander, that the rules have not been narrowed. But the issue of the rules being narrowed is not my words. These are Mr. Badlander's words. He said that he cannot understand why we are complaining about the introduction of gross negligence, because that works in our favor, because it narrows the scope of the transgression. So now when I use his words and I say, well, even the narrowing is illegal because it's a form of amendment, he says he doesn't know where I got that from. I got it from him. He is the one who argued that the introduction of gross negligence narrows the scope of the, and I'm saying that's illegal too. It is as illegal as the expansion of the definition, which is done in respect of incapacity. So it goes back to, I think it was Justice Theron who raised this issue. The sole question is a simple one. Does the introduction of these words in respect of incapacity or retrospective, or rather misconduct, narrow and or expand the constitutional definitions? If I'm wrong on that, that's the end of my submission. But if the definitions do expand on and or narrow the constitutional definition, then it is unconstitutional, it's not allowed, because there's only one way in South Africa to amend the constitution. It is by following the prescripts of the constitution. You can't do it through the back door. So, and then really to revive this argument is I don't even know if I should address it, but let me do it in case somebody actually takes it seriously. What Mr. Badlander says in his last submission is that so what if the incapacity definition has been narrowed? Because Advocate Mkhwebane has not been charged for incapacity. That was an argument which Justice Saldanha in the previous, in Part A, accepted, but it was rightfully rejected in the High Court for the following reason. We are always talking about objective unconstitutionality. So on this formulation, which we hear now for the first time, it would be impermissible for somebody to say the rules must be struck down because they discriminate against women, let's say. And the answer that Mr. Badlander would bring to that would be, but Mr. Mpofu, you are a man. So what business of yours is the fact that the rules are unconstitutional because they discriminate against women? I mean, what is that? How can you say that the rules must pass constitutional muster because Advocate Mkhwebane in particular, it has not been charged for incapacity? Because next week, the chairperson of the IEC will be charged for having COVID-19 for 2 weeks. And then we say, oh, now we can deal with it. So the issue of the expansion or non-expansion of the has got nothing to do with which applicant is raising the or whether she or he, for that matter, is actually the incapacity objection is for 2 reasons. It is
Mr. Mpofu, before you state the 2 reasons, the 10 minutes is up. How much more time do you want?
3 minutes.
Thank you.
Yes. It is to support, as I've already said, when I called it coupling, I think. It is to support the retrospectivity ground of cross appeal, which is anchored on the notion that here the retrospectivity is relates to substantive a substantive ground, and those 2 things are related in the following fashion: that that's what I said. You have to assume for a minute that I'm correct in saying that the rules are substantive rules to some extent, number 1, and I'm also correct in saying that those rules expand or narrow or restrict or whatever term you want to use impermissibly the definitions. Now, if that is so, then the rule, the presumption against retrospectivity applies willy-nilly, and therefore the last point is, I've never heard of a submission that says, going back to the freshly raised issue of urgency, that says that, in fact, this was rejected when I raised it in the Public Protector and Commissioner of SARS matter, rightfully so, that no, you must hear this matter now because it will take long if it goes to Bloemfontein. Well, I mean, the simple answer to that is, it's like saying, no, let's just run roughshod of a criminal matter because it will take long to give somebody the right to cross-examination. It's just going to take us long. Let's just skip it. You can't do that. If indeed the rules are unconstitutional for the reasons that we have advanced, and this court should have the benefit of the SCA in distilling that question, then the answer cannot be, no, let's just bypass the SCA because we're in a hurry, because the DA is in a hurry for some reason or another, which is unspecified. And then you are told that in another answer that this was a political judgment. I mean, in which world does the same party that is telling you that a judge should perform this function, in the same breath tell you that it involves political judgment, and in the same breath tell you that it is at the core of judicial function? Since when are judges at their core to determine political? So that's why they're speaking from both sides of their mouth. On the one hand, They want this court to endorse the unlawful appointment of a member of the judiciary, which is the ultra vires cross appeal point. And in the same breath, they want to tell you that no, actually, this whole process is about political, which is true, by the way, is about political judgment. The two cannot sit together. If it's about political judgment, which we agree, and which the High Court also said, then you can't involve judges in that kind of thing. It must be done right through, as the Constitution prescribes, by members of the National Assembly, who are by definition politicians, all 400 of them, including the Speaker. They are politicians. So it's really rich coming from them to remind this court that it's actually a political judgment. On cost, all I can say, Justice Matlanga, is we have made our submissions that the costs should be on a punitive scale, as for the reasons that were given in the case that I cited, where you not presided, where you gave the judgment, the public protector and commissioner of SARS, and also the SARB case, because we have shown here more than ever that that's why I was shown to that oddity, that the Speaker has not merely come to this thing and said, look, we want to get the best rules, let the courts guide us. If she had done so, this process, by the way, would have been finished a long time ago in 2020, because we begged and begged to say, please concede the interim order that the rules will not be applied. And then next week or next month, we will go and do part B, and then the rules will be found constitutional or unconstitutional, and then we will impeach or not impeach. The people who are now being accused now scurrilously of wanting to delay the process, we were saying, please, let's do away with part A so that we can get on with the real show and get to part B. And they refused unfairly and in malafide. The Speaker said, no, we will not do that. And the result is that it's 2021 now. And the process that we had recommended in 2020 would have resulted in the impeachment 18 months ago. It was even before COVID. We said to
3 minutes is long up, Mr. Mpofu. The 3 minutes is long up.
Thank you, Justice Malanga. All I'm saying is that for the reasons which are spelled out in the replying affidavit, I think in particular, even in the founding affidavit of the supplementary papers, the conduct right through here is not the conduct of an impartial Speaker, as is prescribed in Section 195 of the Constitution. And for the reasons that habitually public protector is given punitive costs, a Speaker who behaves such as in the manner that we have put out in those paragraphs should also attract the opprobrium of this court. As the court pleases,
Mr. Mpofu.
Thank you.
Mr. Mpofu, if I have just one question for you, and yes and no answer will satisfy me. The definition of misconduct introduces gross negligence. Isn't that to bring it in line with our jurisprudence that if one imposed, if one left out gross in the word gross, it could have a chilling effect on public officials in the performance of their duties? Just a one sentence or one word answer will satisfy me. Thank you.
Yeah, well, I'll give you a one sentence answer. The one word answer is no. And the reason is because the reference there is not to gross misconduct, as you say, Justice Pillay, it's to gross negligence. That's a completely different matter. So if you bring gross negligence into the picture, as Mr. Badlander correctly said and then retracted in reply, you are narrowing the scope of the transgression, and that's what's wrong with the picture. in the sense that by now introducing gross negligence, you are making people who were before the 3rd of December 2019 not vulnerable to impeachment by gross negligence to be vulnerable to that. So you're altering, but also you're narrowing. So gross negligence is not the same thing as gross misconduct.
No, I meant gross negligence because the word gross appears before the word negligence, but it's in the definition of misconduct. And if the word gross was left out, then the idea of public officials being of action against public officials having a chilling effect on their performance is a question, but thank you for the many sentences that you gave in response.
Yeah, no, well, unfortunately, I'll give you another sentence.
No, I don't need it.
If the word gross was left out, the situation would be worse because you would have mere culpa negligence. That would even be worse. You'd now, gross negligence at least is something that is sometimes called recklessness, but we know in our law that it is less than dolus eventualis. But if you left out that word, it would then be mere culpa, which would even be worse. That would be a narrowing over the narrowing.
Thank you, Justice Madlanga.
Thank you very much to all counsel. Judgment is reserved. Court adjourned.
Thank you. And to the court.
Today's proceedings have concluded. The host will now terminate the meeting.